Hey guys, I'm here with Bruce to read these new documents in Mike's case out in California. It's mostly pertaining to David and his weird attempt to intervene in the case after deciding he wouldn't be Laura's lawyer, or kind of deciding, I don't know. So we're going to talk about that, but we won't be looking at the body cam footage tonight. I know it's all up on YouTube now, but that is a lot of footage to watch. I have maybe gone through 20 minutes total. I just can't today. Bruce, you watched some of it too. What were your, what stood out to you, I guess?
It gets pretty intense. A lot of it, because there's whatever it is, 16 cameras, because there's 16 people or whatever it is.
Yeah.
Some of it's a little repetitive. You get the guy looking in the garage and you get the guy behind the guy looking in the garage. It's okay.
Right.
I think when we read through the police reports versus the video, it's very accurate. So the police did a good job of writing in their reports what is reflected in the videos. From my perspective, I think the videos, it can be a tough watch, because there's definitely some, heightened emotions, and there's a lot going on. And of course, there's police everywhere. So it's just one of these things, you gotta.
Is that not a normal 7 a.m. routine for you? By the way, guys, it was before 7 in the morning, in case you didn't hear.
Yeah. And I don't think I've lost any weight. I just got a haircut, so.
Oh, I saw that, yeah.
I have less hair.
Comment, but.
So I guess I theoretically weigh less.
Yeah.
I don't know why people are asking
so
me that.
I only saw number 13. I only saw video number 13 in full. So there's a lot that I haven't seen, admittedly. But when I looked at the writing, right, I think the version of events is accurate. I think what they're writing is accurate. That's what happened. But as far as the kind of emotional outburst that I'm looking at and the aggression, that's not exactly what I was expecting. I was expecting her to act a little crazy, right? But I wasn't expecting her to be shrieking and screaming "fuck you" and flipping off the camera. I think that was insane. I was that is not at all what I expected, actually.
It's a lot for sure. Yeah.
I feel that she usually has the time to kind of calculate her little emotional displays, so maybe that's why. But that was the first time I've ever seen her in a way that I would actually describe as histrionic. That was fucking nuts. That was nuts. Wow. And then people are saying the cops were so polite. They really were. And she was such a bitch. It was insane. And her saying they're acting like I murdered somebody. And I'm well, you murdered your unborn children when you decided to have fake miscarriages. So I mean, I guess you kind of did, right? But
oh boy.
Not that the kids were real either, but fake miscarriage is a choice.
Yeah, I mean that's a good point, because in some of her later Medium blogs before they took them all down or whatever, her story was kind of well, I thought I was pregnant and then I guess I miscarried somewhere along the way or whatever, right? As opposed to this fraud as an alternative. But if she was literally pregnant and lost these babies to a miscarriage that she didn't even understand and failed to go get OBGYN care, failed to go get...
she texted the hotline. Yeah. What else was she supposed to do, Bruce?
Failed to get fetal heartbeat monitoring, failed to get ultrasounds, failed to see the high-risk specialist. To me, that is negligence that far exceeds the nefariousness of fraud. Because it's if you literally were pregnant, you basically neglected your babies to the point that they died. I mean, and sometimes, a lot of times, right, these miscarriages can't be controlled.
Yeah.
But she didn't do due diligence, if her story is correct, which I think is even worse than what the more likely actual answer is, which is that this was all just a con job.
Yeah, I can see that. So I haven't actually heard this part yet, but I've seen a lot of people referencing it. Her screaming she hadn't done anything wrong, she only became pregnant by The Bachelor, was ridiculous.
Yeah.
Did you watch that?
By the fucking Bachelor, not just The Bachelor.
Oh, sorry, my bad. But they didn't actually. Never mind.
Yeah, it was kind of well, it's you didn't get pregnant by the fucking Bachelor, you got pregnant by the
blowjob Bachelor,
blowjob and grinding Bachelor.
Jesus Christ. Oh, that's
To
so
be
embarrassing.
accurate, and you know I like to be accurate.
Well, like, look at her behavior even in court when she had her little meltdown moment. It all felt very calculated. Her meltdown was extremely tame. It seemed like she was really okay, to be honest. She just didn't know what to say, so she was kind of like, "Oh, I'm gonna cry so I can get a little break here." And then you look at this. This is what these people in these situations actually look like. When you corner somebody like this, who is not used to facing the consequences of their actions, always finds a way around things no matter what. Around things no matter what. You corner somebody like that. This is what that actually look like. That looks like that raw emotion, that kind of outburst, that aggression towards the
Mhm.
cops. That's you can't stage that. She wasn't prepared for that. She had no idea it was
Yeah.
coming.
It
Versus like her
reminded
other kind of calculated medium posts and her
Oh, yeah.
little Facebook video where she's crying but not crying. There were no tears. It was insane. Like I don't know. There was a very stark contrast there. I felt like this was like a genuine display of distress and emotion that I have not seen or really read from her before. So
It reminded me, number 1, of, like, a panic attack, and number 2, of more like a childlike approach to conflict. Like, "I wanna see my mom. I wanna see my dad. You this is gonna you guys are hurting me. This is gonna make a bruise. See, this is inappropriate." It's like a temper tantrum when a kid doesn't get their way, right?
yeah. Anyways, guys, I know that those are all up on All the Best channel now, and then I know Schnitzel Ninja is doing a compilation where she's putting them all together in like a
Mhm.
certain order. So that should be up soon. I can't. I don't want to speak for her, so I don't know if it's gonna be tonight or tomorrow, but that should be up soon. And then also, I heard that JFC Instagram had some clips as well, so we're starting to see that kind of come out all over the place. But I just don't have any more info for you right now because I haven't watched it all. So that'll be something for tomorrow, I guess.
Yeah. I mean, people are gonna, take their time and analyze things and look at it, and different channels will look at it, and different people make different cuts, and
Yeah.
um, that we'll learn a lot of things over time. It'll be good to have
Yeah.
different views of it, different voices and everything. It'll be good.
Yeah, yeah. So these court documents we're about to read, this is for Mike's case out in San Francisco, where she's trying to get that permanent renewal of the DVRO and all that. David jumped in and he kind of backed out a little bit, and then he came back and said he wanted to intervene after Omar filed the motion to disqualify him. So we're going to go over the documents that they sent in response to that. They're having an emergency hearing tomorrow. It's supposed to, I think it's like 1:30 in the Bay Area, that time zone. So Steve, the guy who went and got these documents for us today and has been doing that for a while, is actually going to come on and talk to us about the hearing because he's going to attend
Oh,
that.
awesome.
He's going to come on and talk to us about that tomorrow, probably
Do
like
we know what that's
5:30.
for, or we'll find out tomorrow?
It's for this motion to DQ thing, I think. So we're about to read about it because they talk about why they asked for that, or Omar did. I
Okay.
think I kind of skimmed over this, so I'm not
Hmm.
really sure yet. But let me see real quick. Okay, so he has two different declarations. We're going to read this one first. Declaration of Omar Serrato in support of opposition to David Gingras' motion to intervene, strike sanctions, and motion for disciplinary referral to state bar. So, David was trying to get disciplinary action against Omar for, well, reasons. We all went through that. It was kind of incoherent drivel at some points, but, it is what it is. I guess he's going to address that now, though. So, give me 1 second, real quick. Let me get my water. Okay. People have been making fun of me because I have not been on the camera a lot lately, and
Oh,
I was getting a lot of complaints that I would like disappear for a minute. And I was like, so I started telling everybody I'm taking a sip of water when they couldn't see my face, so like the stream didn't cut out. And now everybody has this running gag. Oh, Lauren's taking a sip of water anytime I take a split second to do anything. So it's yeah, okay. Anyways, just everyone likes to make fun of Lauren. That's fine. I'm
you
fine.
can't win.
No, I can't.
Everybody wants to watch you 24/7.
Well, I used to just drink the water like a normal person, and then I got a lot of complaints that I was drinking the water too loud. So there's nothing I can do. We're all just gonna have to wait and deal with it.
Drink softer.
Yeah.
What?
Yeah, I know.
Can you make it like wider so we can see the more of the page instead of the gray space? Is it possible? I don't know.
I can try. I'm actually not sure how to make it wider. I can zoom in and out, but I can't. I don't know if I can. Did that help?
Yeah. Or is it shifted over? I don't know. Or can we put
It
our
shifted over a
pictures
little
somewhere?
bit when we. Hang on, let me see. Yeah, there's
I
not
don't
like a
know.
scroll thing down here, so I think we'll probably just have to deal with it for tonight. But I'll
Okay.
try to figure that out later. Let's see. Okay, we don't need to do this here. This is known. They're just talking about the DVRO history. Attorney David S. Gingras was directly involved in matters affecting respondent, including the June 10th courthouse incident in Arizona, which is now a disputed factual issue in this renewal. Based on my review of filings and Gingras' own description, he contacted law enforcement regarding respondent that day. Respondent contends this was improper. A bar complaint has been filed and a disciplinary investigation is pending. On August 15th, Gingras appeared for Owens, indicating to the judge he believed this hearing would take 15 minutes. It's a little more complicated than that. I sought a long-cause evidentiary hearing, which the court granted. On August 18th, I participated in a 66-minute telephone conference with David Gingras and Rachel Juarez. The purpose of the call was to discuss the case, including potential paths to resolution. It was expected that the call would take 5 to 10 minutes.
Uh-oh.
Although the call began on those topics, it quickly became clear that resolving the case was being overshadowed. Gingras diverted the discussion to matters unrelated to the case, expressing opinions and grievances not pertinent to the issues. These included personal concerns and unrelated matters without advancing any resolution relevant to our legal proceedings.
Like what? He can't get the Reese's peanut butter Oreos anymore or something? Like what are his grievances?
Yeah, I don't know.
What?
Like, I don't know how that would have gone. Like, imagine if you were on that phone call, just the way it's being described right now. I'm like,
I had to sell
phone
my
call.
boat.
He's a boatless sad boy summer. I mean, I guess it's fall now, but still. Okay. Wow. During the call, Gingras stated in sum and substance that he wanted respondent's testimony and that such testimony would aid in his defense in a pending Arizona State Bar investigation into Gingras' conduct. God. When he made that point, startled by the audacity of the statement, I loudly exclaimed that was a conflict of interest. Gingras was taken aback by the allegation. I had largely allowed him to speak while remaining quiet. I mean, most people do, it seems. And yet still, he's like, well, that person was a bitch. You know, like, you give him as much time in the world to talk, he never makes a really good point, and then he's still just like, well, that was rage bait. No, sir. You had the floor, like, all night. You know what I mean?
I wish I had a recording of this call because I estimate that 56 to 60 minutes of the 66-minute phone call is Gingras talking.
That's awful. I would not want to hear a recording of that, actually.
Well, just to measure how much talking he actually does.
It's totally tempting to be like, I would love to be a fly on the wall in that, but then I really think about it and I'm like, no, I would rather die. So I think not. But
for science.
For science. I'm not dying for science. Okay. Where are we? The request to collect respondent's testimony for his own defense could potentially compromise privilege or intimidate witnesses, thereby prejudicing my client's position in the process. I explained that Gingras is a percipient witness on contested matters, particularly the events surrounding June 10th, and that his stated intent to obtain testimony he believes would assist his own disciplinary defense created a problem. I feel like that seems pretty obvious, but he seems to disagree based on what he said. I don't see how, but okay, you know.
Well, he likes to disagree.
No, that's definitely true. Okay. Gingras disputed that any conflict existed. In substance, he said his interests were aligned with petitioners. Well, that I somewhat agree with. That his prior actions were proper, and that client consent could address the Rule 3.7 issue. Regarding that representation at the time, prior to researching the issue, I was uncertain whether client consent was a cure-all for a 3.7 issue, so I remained silent.
Very good.
At no point during the 66-minute call did Gingras say he had already withdrawn, nor did he commit to withdraw going forward. When the call ended...
That's the key, right? Because if he said to them, hey, in writing, I'll say I'm not going to be on this case now or ever in the future, they would be done.
Yeah. I don't know if that even would have been enough, because like he flip-flops so much, and also it sounds like he was kind of erratic.
Yeah, but I mean, if you get it in writing that he's not going to represent her now or in the future, and then he changes his mind, you could file these motions at that point, I suppose.
I don't don't know. I wouldn't take the written word of a coked out asshole, but that's just my opinion. So, can I prove he was snorting? But no. But like,
Well,
I feel
it
like he
just
has been.
shows that, he made an agreement in bad faith, right? So it would be bad. It would be a bad look for him if he went back on his word.
Nothing's a bad look for David. He makes everything look good. I don't think he would care about that. He sounds like he's a little off his rocker these days. So I would actually not take that. I would not accept that. I'd be like, I believe this guy's going to change his mind. He's all over the place. Nah, no.
Okay. You'd want to have him disqualified for sure.
Yeah, the word of an erratic psycho really means nothing in a long-term sense. He's going to change his mind.
Mm-hmm.
All right. Let's see. In fact, we talked about the possibility of continuing the October trial to a later date. This is just talking about his history of Laura. We had spoken on August 14th for 18 minutes and 16 seconds. It's very precise. Where he indicated to me that he was going to represent Owens in these proceedings. Mm-hmm. Throughout the 66-minute call, Gingras spoke rapidly and, at times, digressed into personal matters. So kind of like I do on these live streams, but I'm not a lawyer. So it's fine. Including references to his state bar exposure and DUI arrests. Oh,
no.
Oh, that's embarrassing. Okay. It was difficult to keep him focused on relevant issues. Those digressions reinforced my concern that his personal situation had become intertwined with his role in this litigation. Yeah. Well, how do you know he wasn't drunk when he said he would withdraw at that point?
I wonder what he said about his DUI.
I wish I had more information on that. Yeah, but I don't.
I know. Well, it's just we don't know, but it would be interesting.
I don't know what they're gonna talk about at the hearing. Really, how much they're gonna get into that. But I mean, I'm sure Steve will be able to tell us if they say anything about that. So. Okay. Let's see. Based on that conversation, after consulting with respondent and co-counsel Rachel Juarez, we determined it was necessary to file the motion to disqualify David Gingras. On wow, I cannot talk tonight, dude. On August 21st, the motion had been drafted, and I was preparing to e-serve Gingras when I emailed him asking for permission to serve him electronically. He asked if I had time for a quick call. Dude, I've never seen somebody who claims
to talk on the phone.
No, I've never seen somebody who claims to hate somebody so much be like, I want to spend more time on the phone with you. In this day and age, no. Like, what are you doing? What are you doing? He indicated
who wants to talk on the phone? Nobody wants to talk on the phone. Come on.
We spoke for 16 minutes. That could have been an email. Just saying. All right. I asked him to confirm that he was not representing Owens in writing, which he provided. Ordinarily, if opposing counsel orally represented that he would remain off the case, I would accept that and proceed accordingly. However, this was not an ordinary circumstance. There are undisputed facts, such as his behavior during the August 18th call and the conflicts identified under Rules 1.7 and 3.7. These are factual observations. Based on these, I believed relying on an informal assurance that he would stay out of the case would not have been prudent or fair to the court or my client. The procedural risks included the potential for an 11th hour continuance or even a mistrial under California Rules of Court 3. What the hell? Okay, which mandated a formal approach. I don't know what rule it is.
Wow.
There was no formal withdrawal on file when we spoke, and no substitution of attorney had been executed. He represented that he tried to file a substitution of attorney into the case, which may have been rejected. Well, he's used to rejections. That's fine. What I had, most of them are from teenagers, though. What I had, at most, was an expression of intent that he did not plan to proceed as counsel. In light of the above factors and given the approaching evidentiary hearing, I could not responsibly expose my client or the court to the risk of a last-minute re-entry or a rolling dispute over Gingras' role on the eve of trial. Okay, so as far as him not being her attorney anymore, I know we don't really know anything about what she plans to do moving forward. And so I'm curious as to, like, has he had to reach out to Laura directly? Is Laura even responding? If so, how bad is it? Like, I don't know. There's a lot that I have questions about, but obviously can't get the answers to. So,
are you saying has Laura been communicating with Omar?
Yeah. Mm-hmm.
Yeah, that's a good question.
I feel bad for him if so, but I know he has to do that. So,
like, I'm not sure because so far it seems like we've just been seeing these motions related to Gingras as opposed to motions about the actual DVRO. We've been on this side train for a while, right? But there could be things going on in the background that we don't know about. So
yeah, sure. I'm sure there's a lot, but whatever. Oh, thanks, Robin, for the $2, making sure you make some money to piss off David. Well, anything that I make is going to go to Mike's fund. The problem with that is they don't pay you on YouTube until like the end of the next month, so it takes a while. But anything we make here is going to go to Mike's fund. We'll have to just give it to the Gibson Go or whatever, or the GoFundMe. I can't remember which it is. Actually, if one of you could pull up Mike's fundraiser and link to that in the chat, I would appreciate it. So, okay. So, I further anticipated that once Gingras read respondents' pleadings, which necessarily characterize disputed facts and contradict portions of his prior sworn declaration, he would be triggered by those unflattering characterizations and feel compelled to re-enter the case to defend his own narrative. That concern was not speculative. It was based on A, his statements during the 66-minute call that he wanted respondents' testimony to aid his own bar defense.
Oh boy.
Okay. And B, his demonstrated tendency to personalize disputes and to respond publicly and aggressively when his conduct is criticized. Well, I've never seen him do that. God damn. I'm actually surprised he hasn't like gone off on his diary tonight. You know what I mean? So,
well, give him a day or two to get on that.
That's a long time for him to wait, but I'll give it that. All
Maybe late tonight he'll get onto it and do a good blog.
I hope to God I'm asleep by then.
Well,
but all right, let's see. We hoped Gingras would bow out gracefully. He did not. In my judgment, leaving the issue to informal assurances, invited a yo-yo counsel scenario, re-entry when filings displeased him, followed by renewed conflict objections and delay. By filing the motion to disqualify, the court would be on notice that the issue was raised at the earliest possible time, that Owens would have had time to obtain alternate counsel, and avoid a situation where she asked the court to continue the hearing in October to obtain new counsel. We wanted the court to know this issue had been addressed in August, so it would not be a surprise if raised in October. Okay. Nice. For these reasons, out of caution, I filed the motion to disqualify. The goal, I thought he just did it to lie to the court. That's what I read somewhere else. I don't know.
Oh boy.
The goal was not to punish Gingras. It was to A, formalize what he suggested informally, B, eliminate the conflict-driven risk of his reappearance as advocate, where he is also a witness with personal disciplinary exposure, and C, preserve the integrity and appearance of fairness at the upcoming evidentiary hearing. In my view, based on what I personally heard and observed, relying on an oral assurance in this setting would have been imprudent and potentially prejudicial to both the court's management of the case and to my client's rights. I therefore sought a definitive ruling so that all participants would know who is and is not counsel, witnesses could be prepared without ethical entanglements, and the merits of petitioners' renewal requests could be adjudicated without the collateral distraction of an advocate-witness conflict surfacing mid-hearing. My decision to proceed by motion was made in good faith, after much discussion, driven by the unique facts surrounding Gingras' status, conduct, and conflicts. On September 12th, Gingras, not a party, filed... I mean, he's never invited to parties, so filed papers styled as an intervener, seeking to intervene, strike my disqualification motion, impose sanctions under CCP 128.5, and obtain a disciplinary referral against me. I did not receive... What's that?
Because I was always wondering, what do you call... If he's not a party or a litigant, and he's filing something, what do you call it? And Omar calls it filing papers, which I like.
Sure.
That's good.
All right. And obtain a disciplinary referral. So here's the funny part. I did not receive a 21-day safe harbor service sanction of any sanctions motion before Gingras filed it. After he made such a big deal about Laura and not getting the safe harbor period in her case in Clayton, he didn't serve Omar with a safe harbor notice. Like, what?
Yeah, Echo says it's not an amicus brief. Yeah, exactly. I don't know what to call it. Papers. It's just random papers. That's what we're calling it.
I can't keep up with like Laura didn't get her safe harbor over and over and over again, and then taking it all the way up to the Arizona Supreme Court, and then not giving a safe harbor service to Omar.
Even
Like,
though when I read the filings and I do the math, it seems like they did have a safe harbor period. But anyway, that's
you have to
in the
actually serve
past.
him with something though, and he did not, apparently.
In
So,
what? In this case?
yeah.
Oh yeah, for sure. I mean, I
So
agree with this.
he's seeking
I'm talking about the
sanctions against
Clayton
Omar.
case.
Yeah. No,
In the
I'm talking
Clayton.
about this one.
Oh, okay.
That's why I think it's so funny, because he harped on that safe harbor thing so hard over and over and over again in Laura's
Yeah.
case, and then he's like, "Oh, I don't need to do that. Fuck it." That's
Well, in the Clayton case, it didn't matter. But even if it did matter,
no, of course not.
even if it did matter, she had the time window. So
Yeah.
I think it's wrong either way.
Oh God. Because the DVRO evidentiary hearing is imminent and Gingras' motion risked disruption, I requested that the court shorten time for hearing on his motion so they could be resolved beforehand. An expedited schedule would prevent last-minute motions from overwhelming the court and ensure the integrity of the DVRO hearing. By addressing motions in advance, the court is better equipped to manage its docket efficiently and to safeguard against procedural delays. The motion to intervene, along with other relief requested, is deficient on its face and may be dismissed on procedural grounds without exploring the merits of the motion, although our opposition addresses the merits. Shortening time would allow the court to dispose of this side issue quickly without muddying the waters of the issue at bar, the DVRO renewal. Oh, here we go. I operate a YouTube channel and have done so for several years where I create content offering legal commentary. There are 413 videos, 18 of which related to the Laura Owens cases and her upcoming criminal prosecution. The last of these was created on July 10th. At that time, I had no professional affiliation with this case. I have not created case-related YouTube content since my appearance. I have not published any YouTube content about Owens or Gingras since I appeared as counsel in August 2025. Unfortunately, only one side of the line can say that at this point. I do not control third-party creators and have not directed or coordinated their content. That's right, guys.
That's true.
Omar Serrato is not a sponsor of my foul language or opinions. That is, I am entirely free to do that, despite David's, objections.
The nice thing about this, in comparison to Gingras's papers, is that this is very quantitative, right? He says these were the specific number of videos of each category. These were the dates of the final videos. There haven't been any videos since this other date. It's very specific, right? And has real dates in here that you could take these two bullets and go check on YouTube and independently verify it. And that is what we like in our independently verifiable evidence, which Gingras doesn't put in his papers, or at least not often. You're on mute, Lauren. What's going on?
Well, I went to unmute myself and I realized I never muted myself. So, all right. Well, none of my videos contain threats of violence. Phrases like, I can't believe you had to explain this, by the way. Phrases like "want the smoke" are common. I wish he would have used like Urban Dictionary in a footnote or something. But are common slang used figuratively in legal commentary to mean "do you want the conflict/challenge?" Not a literal threat of harm.
Wow.
Any thumbnail depicting a caricature of Gingras was satirical/meme style. Again, I can't believe he's having to explain this. And intended for comic relief. I have never threatened Gingras or Owens. It is my personal experience with Gingras that he often vigorously attacks anyone who opposes him, including Judge Mata, the Maricopa County judge, we know that, and his opposing counsel Greg Woodnick, who he's gone out of his way to tell me personally that both of them have either broken the law or lied to the court or violated rules and should more or less be in jail.
It's crazy. Every single person he disagrees with is like a criminal automatically. Like, there's not that many criminals out there. Like it's so, Dave Neal, Megan Fox, Judge Mata.
You just
Greg
named
Woodnick.
like 3 criminals.
They're all criminals, right? Like, it's all this big conspiracy where they're all constantly breaking the law, and only Gingerbread Gingras over here is strictly following the law and an upright citizen, and he just has the utmost respect for the law and the rule of law. Come on, man.
I don't know who's going to get this reference. I feel like he's like the Amelia Bedelia of lawyers.
He's the...
Does anybody remember that book or those books?
I do, but I don't remember like the plot.
It was like a book about Amelia Bedelia learning manners, right? And so she would do it wrong though. And then you would have to pick between A, B, and C, which was the correct thing to do. And Amelia Bedelia always did the wrong thing.
Oh no.
Hey, what's up, man?
Oh my
You're
God.
Hey, how's it going?
Hi, Lauren. Hi, Bruce.
We got our friend Echoes from
Oh
the
my
Tabernacle here.
Oh my God. Now I've got to remember where the hell I put my camera.
It's
It's
in
definitely
front
on
of
your
you.
face.
Everybody.
We can
I
see
do have
you.
a face. I know. It's
Holy
great, isn't
heck.
it?
This is
Technology's
breaking
amazing.
news, guys. This is
breaking news.
Oh my
Oh.
gosh. Have I seen your face before? Usually I only hear your voice.
Well, I do have a couple of videos at the beginning of my life on
Oh,
YouTube.
that's why. Because I've only seen
But none of it's about this. So,
Okay.
yeah.
amazing.
All right. Well, good to know what you look like, man.
Yeah, likewise.
Now, I'm going to finish the rest of this one and we'll move on to the next one, but we're almost done with this first one here. Let's see. It is my personal experience with Gingras that he often vigorously attacks anyone who opposes him, including Judge Mata and his opposing counsel, Greg Woodnick. We just read that part. I have personally viewed David Gingras created content attacking these individuals on his YouTube channel. I think he conveniently left that out, yeah. Although all that content has since been unpublished, don't worry, it's still around. Likely because he is under investigation by the Arizona State Bar. It stands to reason that I would not be insulated from those attacks. I personally observed posts on Mr. Gingras's firm blog. The fact that he uses his firm blog and social media in which he boasted that YouTube approved his copyright strike against a small critic and celebrated the takedown with hashtag justice for dingus. And that was the loud little ducky strike.
I mean,
was
is
an
his
epic
blog
moment.
really that firm? Come on.
I don't know what Ducky's up to tonight. I hope she saw this though, because it's fucking hilarious. It's actually in an exhibit too. Like his blogs and stuff are in exhibits. Previewed and teased his sanctions filing publicly, and then used his blog to accuse me of having straight up lied to the court and to announce he would seek sanctions and a state bar referral against me. I personally viewed public postings indicating that Gingras sent threatening communications or demand letters to content creators Dave Neal. Did he threaten Dave? And Megan Fox regarding their coverage of Owens' cases, and that he demanded that coverage cease or be altered. I can attach the relevant public posts/videos. These are not my communications. I observed them as part of monitoring the public discourse referenced in Gingras's filings.
Oh,
dude, why do you do
interesting.
this? Like, why does he do this in his public diary? That's the problem for this guy.
He needs a therapist.
Yeah.
At
Exhibit
least put it behind a
C&D.
paywall.
That's another good thing because like Omar here is saying like, okay, this guy has sent terrible things to Dave Neal or Megan Fox or whatever. And he doesn't just say it. He says, go look at it yourself in Exhibit C and D. That's very good. Like that's what we miss in Gingras's papers. He doesn't really do that.
I don't remember what it's like to read a normal lawyer's writing at this point. It's like angry Blake Lively or Justin Baldoni's filings because they're all attacking each other, or Gingras writing in the court like it's his personal middle school diary. So, yeah.
Would we have anything to say though if they were normal?
No, I thank God this guy never went to therapy. I mean, I would have nothing to talk about.
That's it.
Imagine if he had gotten a psychiatrist. Like, I would be so bored right now. What would I even be doing? Probably be sitting downstairs writing in my own diary. Fuck. Thanks, David.
It's something that Omar's filings are the most normal filings we can find.
I do love Omar's
That
writing.
really is something. All right. The items discussed above demonstrate that Gingras has been actively waging a personal online campaign against critics and against me. This is the only smear campaign I believe in, guys. And that his motion practice here is consistent with that campaign. I honestly wish he had written smear campaign just so I could like dot on him later. Based on these observed actions and consistent behavior patterns, it is my belief he filed this motion to stir controversy for the public that follows this case. He filed this motion not due to legitimate legal concerns. He filed it because he felt personally attacked. Oh, geez. Gingras's attempt to introduce a Riverside matter as evidence of prior misrepresentations is confusing. The court expressly found no misrepresentation in its ruling on the Riverside matter. That was a motion to allow the filing of a cross complaint that was supposed to be filed at the time of answering the original complaint. Opposing counsel accused me, Omar, of making intentionally false statements because the proposed cross complaint was signed at the time of the motion for relief. Wait, I don't get that. Someone help me out here. Opposing counsel accused me of making intentionally false statements because the proposed cross complaint was signed at the time of the motion.
David in his filing made lots of accusations of that.
Okay, yeah.
So I think that's just in reference to that.
Okay. I got confused. The court rejected that premise, explained why the accusation okay, so this is still talking about, because it said me, and I was like, Omar, what? The court rejected that premise, explained why the accusation failed, and granted my motion. If helpful, I can produce the ruling on that matter, as I have a true and correct copy in my possession. Okay. I have never been found to have made a material misrepresentation of fact in any court. All right, then. So that was the first one. We're going to move over to the second. We won't have to, I won't read word for word through this one. This is the opposition to his motions. So we actually never saw his motion. I think we said that before, but still, It never came out, and he never released it publicly. Yeah. I don't know if any of you guys tried to ask him for it on Twitter or Blue Sky. But
I mean, even if he posted it, I wouldn't want it. I want to read a copy from the court docket that's been through the court system. Yeah. I don't want.
I would totally read it. To be honest, I'm curious.
Something with the clerk of the court stamp of approval that he hasn't played with later for whatever reason.
I would totally read it. I would totally read it.
Well, it would be good fodder.
Yeah. And then if he changed it later, I would sue for emotional distress. That doesn't make any sense.
That would be quite a settlement.
Yeah, all 13 of the remaining dollars he has in his bank account, apparently, if he's doing this. So,
well, he's got to have a little money from his boat, though, doesn't he?
I mean, he probably spent that on cocaine.
I'm wondering if he's
pure speculation.
I'm wondering if he sold his boat to pay his DUI lawyer.
I would suspect.
I still think it was for the cocaine, but that speculation is as pure as the cocaine he bought. So I don't know. Just saying.
Oh boy.
All right.
Miami Vice was a long time ago, Lauren.
Oh, it wasn't that long ago, Bruce. Come on.
I didn't watch Miami Vice, bro.
See, it's before.
I know
Lauren's
my gray hair
time.
doesn't show up as much on camera, but I'm older than I look.
Yeah,
you look like you have
Miami
totally
Vice.
brown hair. I don't know what you're talking about. All right. Okay, so we got this introduction on August 25th. Respondent moved to disqualify David Gingras. We know all that stuff. On September 12th, Gingras, not a party to this case, responded with a wide array of counter motions, calling himself an intervener. He seeks, 1, leave to intervene in this family law action for the limited purpose of pursuing sanctions against respondent's counsel, which is Omar. 2, an order striking the motion to disqualify in its entirety. 3, monetary sanctions against respondent's counsel. And 4, disciplinary referral of Omar, respondent's counsel, to the State Bar of California, premised on the same accusations of misconduct. That is ridiculous, by the way. Okay. Gingras's filings attempt to inject issues about opposing counsel's conduct into the DVRL process, referencing matters outside the court's purview, such as YouTube commentary and social media. Because these filings could disrupt the DVRL schedule and impede respondent's trial preparation, prompt resolution is necessary. Accordingly, respondent brings the present request for order shortening time, ensuring Gingras's motions are resolved before the DVR renewal trial proceeds. So I guess they're going to settle that tomorrow. This transition clarifies the direct link between disruptions described above and the action now sought. All right, we're getting into procedural history, which you don't need to really read through so much because we've seen all this before. It's just talking about the background, how Mike was subpoenaed to testify in the trial, Clayton and Laura's trial. Let's see. This is funny. Law enforcement denied Gingras's request, finding Marraccini was not violating the DVRO as a subpoenaed witness. And he continuously denies reality in that regard.
To this day. Seriously. And it pisses me off. And then he goes and posts the actual subpoena and calls it fraud. What is the matter with him?
At one point, wasn't he saying a valid subpoena was never, I was never given a copy?
Yes.
And then they were like, it's right here attached to this.
Yeah.
And then he includes it as part of his filing saying it was, David.
The moron.
Oh my God.
Such a moron. Oh my God. All right. A hearing on Owens' renewal took place on August 15th. We know that. Following the August 15th hearing, attorneys Omar Serrato and Rachel Juarez, defending Marraccini, held a conference call to discuss the case. Meant to last 5 minutes, the call lasted over an hour, focusing mostly on Gingras's personal vendettas, impending Arizona State Bar discipline, and DUI arrests. Plural. Okay.
I take back what I said in chat now. Now I want to hear it.
Oh, that phone call?
Yeah.
I still don't, dude. I do. I mean, I still do. Sorry.
What is left for him to complain about? Other than just to keep rehashing everything he's been
exactly.
saying
What is his list of grievances? This isn't Festivus or anything, right?
I want to hear like I don't know, is Cliff Notes still a thing, guys? Do we still have Cliff Notes, or has that been taken over by AI?
You want the Cliff Notes of the phone call?
I do. If I like I said, if I could be a fly on the wall, I don't think I would want to listen to an hour, but I want to hear the Cliff Notes.
My one criticism of Omar so far is that he was about to do a phone call with David Gingras, and he thought it would be 5 minutes. Like, buddy, it's never going to be 5 minutes. No, yeah, exactly. There's no way it's going to be 5 minutes. I could have told him that. So that's my one criticism so far of Omar here.
Yeah.
That's such an indictment, Bruce.
Yeah, I know,
you're so harsh.
Hey.
God.
I'm a tough manager.
Let's see. Gingras spoke rapidly and struggled to focus. He said he needed Marraccini to testify to support his Arizona State Bar defense. Okay.
That's crazy.
I then told him this was a conflict of interest as it brought his personal concerns into the case. But like I said, we don't have to read through all this because we know all this already. We're talking about the disqualification motion. It cited 2 ethical grounds. One, the advocate witness rule, which posits that Gingras, as a necessary witness on key facts, would face a conflict if he continued advocating for Laura in the case, and this could prejudice the trial. And 2, Gingras' personal conflict due to his pending disciplinary case, which creates a self-interest that might influence his conduct in the proceedings. Okay. The motion noted Gingras intended to withdraw and stated it was likely unopposed by Owens, seeking to formalize his exit and protect proceedings from further distractions. Gingras can still attempt to re-enter this case, which is the problem. All right. Rather than withdrawing, Gingras responded to the disqualification motion by filing a motion to intervene, motion to strike, for sanctions, and for disciplinary referral against Serrato. Gingras accuses Serrato of court fraud and gross misconduct. He claims, 1, I misled the court about Gingras being Owens' counsel. 2, the disqualification motion was frivolous, filed in bad faith, and intended to harass him. That's hilarious.
Such a martyr.
Yeah, like this guy harasses people on the daily for fun. He has no job. He has no paying clients, so of course he does. So I guess he doesn't know as much about harassment as he should.
If you're not a party or a lawyer in the case, why does a motion, like, if somebody filed a motion to disqualify me from this case, like, why would I even know or care? Like, who cares?
Well, I'm working on it right now, Bruce.
Well, you can, because I wouldn't care, because I'm not a lawyer on this case.
Gina, thank you for the $10. Speaking of Bruce, Lauren, we all have a crush on Bruce. Love you both. Thank you for great commentary. Oh, okay.
Blush.
Binky, thank you for the $2. $1 for each bird Laura flipped.
That was at least 4. She effed them off twice that I counted. There may be more.
She was
I heard her say, "You guys can all fuck off," but did she flip them off too?
She said it again.
Oh yeah, she did. Both fingers.
She double bird. Yeah.
Whoa.
I would be impressed if she were anyone else.
I couldn't believe it.
We have one more. Thank you for the $5. Fake Laura Owens. Can anybody recommend a reliable maid service in the Scottsdale area? Asking for a friend.
Oh no.
She's gonna use TaskRabbit and then fall in love with the guy who comes to clean the house. It's gonna be bad. All right.
Another Fiverr job.
Yeah, exactly. All right. Gingras accuses Serrato of, we did that, I think, misled the courts. The disqualification motion was frivolous. And also, I am using court filings to run a social media campaign to smear him and build my YouTube presence. This from the guy who wrote a motion to compel lunch. Okay. Gingras asked the court to impose monetary sanctions and attorney's fees on Serrato, strike the motion to disqualify, declare violations of multiple rules of professional conduct, and refer Serrato to the state bar. This just coming from this guy, this is bizarre. But
can we have a motion to compel some sanity with this guy? Is that even possible?
I don't think that's a thing. Otherwise, they would have done it to Laura.
I know. Yeah.
Gingras' filings feature heated rhetoric and personal attacks. For example, accusing Serrato of arrogantly and menacingly boasting about violence. Yeah, that was crazy, dude. Calling his YouTube work sleazy. And describing the disqualification motion as a scheme to defame Gingras online. That is fucking nuts. He was so nice to the guy. He kept picking up his calls. And I know David really wanted to have like a bromance relationship with Omar. And Omar was just being super nice. And then one day we see him finally, he's like, oh, I've had enough. And then he's writing down his little diary. Omar's dead to me while an assault rifle is sitting in the background, which is just a wonderful message to send.
Omar started to connect the dots, and then David got pissy.
Yeah. All right. I mean, if I've ever seen a school shooter, David Gingras would be it. Hopefully they don't let him back on the campus of U of A, where his niece goes. So just saying. Let's see. Points and authorities. I'm not going to like really read through this too much. David Gingras has no standing to intervene in this case. Yeah, I don't want to read too much of this.
Is that really a thing?
What?
Do either of you know? I've never heard that term used for a non-party or a non-attorney representing, appearing in the case, to come in as an intervener. I've never heard that. This is the first time I've ever heard that.
I've never seen that. Obviously, though, because I've only followed 2 cases ever. So.
I mean, I would think the courts would be littered with interveners.
Yeah. Oh, no, man. All right. Under California Code, permissive intervention is appropriate only when a non-party demonstrates a direct and immediate interest in the action. A direct and immediate interest means the non-party will gain or lose legal rights based on the outcome of the judgment itself. In contrast, if the impact on the non-party is merely indirect or consequential, intervention is not permitted under this standard. The permissive intervention statute balances the interests of others who will be affected by the judgment against the interests of the original parties in pursuing their litigation without being burdened by others. If proper procedures are followed, the court has discretion to permit a non-party to intervene in litigation pending between others. Provided that the non-party has a direct and immediate interest in litigation, the intervention will not enlarge the issues in the case, and the reasons for intervention outweigh any opposition by the existing parties. Okay. Gingras lacks direct and immediate interest in the DVRO proceedings. All right. Are you guys able to see this?
Yeah.
Okay. You need to zoom in a little more so you can read. I'll have you read this section.
Yeah.
Just be echoes.
Sure.
There you go.
Hey, it's bigger. Do you want me to read?
Yeah.
I'll
just go through the end of
urge to push a button and make a voice out of it.
I mean, you can do both. I don't care.
Lauren's she's gonna drink her water off camera now again.
Oh, she's got competition. Look at that.
I only do that when I leave the desk, dude.
Yeah.
When I turn the camera off, it's because I'm leaving the desk. Don't tell anyone that.
Big cups.
Hey, a gallon a day, Bruce, and it can't be whiskey.
Size matters.
That's what doctors say.
It can't be
so.
brandy.
But I'm biased. Or brandy in your case, sure. Fair enough. Lauren. It's okay. All right, let's see. Line 5. Gingras seeks intervention in a domestic violence restraining order renewal case between Laura Owens and Michael Marraccini. The underlying dispute concerns whether Owens should receive a permanent restraining order against Marraccini. Gingras has no direct interest in the merits of this restraining order request, as that dispute is strictly between the actual parties. I guess that doesn't mean him. As in David. Although I'm sure he desperately wants to remain a party, but I think he's got ulterior motives. Gingras is...
This is the first party he's ever been to, man.
Oh.
Well, I don't know.
Give the guy a break.
I don't know. I think he parties a lot with co-eds, but never mind.
Oh, dear.
Oh, Schnitzel's not here. We could probably have a good time talking about that. I've heard other rumors, but I'll keep them to myself.
Oh.
We'll talk about it later. No
We'll
worries.
talk about it later. Gingras' stated interest relates entirely to his personal reputation and desire to avoid sanctions, which are collateral to the subject matter of the litigation. His motion seeks relief solely against opposing counsel Omar Serrato, including monetary sanctions, striking of motions, and disciplinary referral. These personal grievances against an attorney do not constitute the type of direct and immediate interest, meaning a stake in the outcome of the case itself, that California law requires for intervention. Whether the restraining order is granted or denied will have no direct legal operation or effect on Gingras, as he is neither the petitioner seeking protection nor the respondent from whom protection is sought. Any impact on his reputation or professional standing would be indirect and speculative, which is insufficient to support intervention.
Okay, this is unrelated, but I have to show you guys a perfect example of something I talked about in one of these other streams. Look at this side of my face, right? It looks fine. My ear looks fine. Look at this side. It's red as fuck.
What?
I get like red ear and red face all the time. And people are always pointing that out to me like, Lauren, why is your face so red? I don't know. Shit just happens.
It's the thrill of being a YouTube star.
Yeah, sure.
Is it really that different?
Yeah, like, okay, look at this ear, right?
Yeah, it's an
And then
ear.
look at this ear.
Well, you have the
Maybe
earbuds.
slightly.
It's pretty red, man.
Well,
If the redness lasts more than 2 hours,
Look
see a
how red
doctor.
that is.
do you get? So I get like hereditary rosacea. So that's why I get like red.
I don't know.
cheeks
My
and
doctors
stuff.
just called it red ear syndrome, and they said
it's
it happens
genetic.
randomly. It makes no
Red
sense.
ears.
Yeah, it's just
I mean-
one ear. It'll go to my cheeks sometimes too, but yeah.
Does that go with red antlers?
No, dude, my antlers are black.
Okay.
Oh boy.
I meant Bruce's.
Oh,
Yeah,
my bad.
We're talking about my antlers, Lauren. Come on.
Sorry.
Oh my god.
Somebody says stop touching it. Why does that make it worse? I can't.
Yeah.
Oh man. All right, let's go down
Oh,
to
no.
see. Attorneys cannot intervene to pursue personal relief in client actions. California courts have specifically addressed the improper use of intervention by attorneys seeking personal relief in their clients' cases. Because an attorney is very unlikely to meet the criteria to intervene and become a party to the underlying action, the fundamental rule is that the attorney is not a party to the client's action and cannot appear on his or her own behalf to seek any relief in that action, including enforcement of a contractual lien against the proceeds of the judgment. Okay. The limitation is founded on the fundamental principle that one who is not a party to a proceeding may not make a motion therein. After the client obtains a judgment, the attorney must bring a separate, independent action against the client to establish the existence of the lien, to determine the amount of the lien, and to enforce it. This sounds way more complicated than I realized. This principle applies equally to Gingras' situation. If he believes he has been wronged by opposing counsel's conduct, the appropriate remedy is through separate proceedings, not intervention in the underlying case. That part seems like a no-brainer, but all right. The law requires a specific present interest in the subject matter of the action rather than merely a collateral interest in the proceedings. Contentions of falsehoods that are demonstrably false do not qualify.
Yeah. I mean, they're basically saying that Gingras' complaints don't have anything to do with this case, and procedurally, his papers are being filed in an improper process.
He's
Even
butting
if
in
you-
where he isn't wanted.
Yeah, even if it made sense to do it, he's doing it in the wrong way.
All right. Fake Laura Owens, thank you for the $5. Raise your hand if you have your lawyer's personal cell number on speed dial. Bone, bone, bone.
Oh,
And it wasn't
boy.
tattooed to her forearm either.
It probably should have been, because they
It-
took her
it would've
phone
made
away. And she didn't
sense.
have his phone number anymore.
I
I
was
can
shocked.
feel myself getting redder in the face. We have to stop.
Uh-oh. Lauren's getting flushed.
Well, maybe it's. Are you sure it's not a bruise because a search warrant
Yes.
was executed and somebody led you by the face from one room to another?
I have never had a search warrant issued for
Oh,
my
okay.
house, but if they did do that,
Oh,
I would
'cause
hope
that
they
could
would
leave a
leave back-
bruise.
they could at least clean up a little while they're going through stuff.
The truth will leave a bruise for her for the rest of her existence.
There you go. Dima Nishuat, thank you very much. Hi, Lauren. Love you and so very proud of you. Showing support for all those court documents that you purchased to keep us all updated. Thank you very much. I appreciate that.
Yay.
These were actually, I got these from the Volo Victims of Laura Owens website, but yeah. So most of the stuff that I had to pay for is from the Justin and Blake case, but I do appreciate you. And everything we earn tonight is going to be passed on to Mike's fundraiser for his legal fees. Not
hit
at the
that
request of
GoFundMe.
anyone involved in this case. I just want to do that. So,
Yeah.
David, please shut the fuck up on your blog. All right. Gingras' intervention would improperly enlarge the issues. He seeks to intervene solely for the limited purpose of seeking sanctions against Serrato based on alleged misconduct. However, this request would significantly enlarge the issues in the litigation beyond the core disputes. The underlying case involves renewal of a domestic violence restraining order, while Gingras seeks to litigate entirely separate issues regarding attorney conduct, sanctions, and disciplinary referrals. Allowing such intervention would set a troublesome precedent where any non-party attorney who feels personally aggrieved by something in a case could intervene to litigate side issues and attack opposing counsel. This is not what Code of Civil Procedure Section 387 contemplates. Gingras has no standing to intervene in this case. He's not a party to the Owens versus Marraccini matter, and as of August 25th, he was no longer counsel of record for either side. Yet he seeks to intervene in the action solely to pursue personal relief against opposing counsel. This is an improper use of the intervention mechanism. The dispute is strictly between Owens and Marraccini. Whatever personal interest Gingras has, reputation, avoiding sanctions, etc., is collateral to the subject matter of the litigation. Okay. There was no need for Gingras to intervene in order to respond to the motion to disqualify. That motion could have been addressed or withdrawn without granting Gingras party status. Typically, when a motion to disqualify counsel is filed, the affected attorney may oppose the motion or submit a declaration without formally intervening as a party. The decision on disqualification focuses on what serves the interest of justice in the case at hand, not on conferring rights upon the lawyer involved. Here, since Gingras had already ceased representing Owens, the disqualification issue was largely moot, or at least not adverse, as Owens did not oppose removing Gingras. In these circumstances, Gingras' intervention serves no legitimate purpose other than to pursue his sanctions campaign. The court should deny intervention and require that any genuine issues regarding attorney conduct be handled within the existing party framework or referred to the appropriate disciplinary authorities separately. Gingras' grievances do not warrant enlarging this case beyond its core dispute.
All right. Get him, Omar.
These are good points. I mean, this is why I was saying, like, I don't, if Laura is unrepresented at this point, like, I don't even know what she's talking to Omar about, because they're just dealing with this sideshow.
Exactly. Right? I mean, I guess they're going to figure that out tomorrow, so they'll have plenty of time before
that. I mean, that's, I guess, the point of all this. They're just applying it to the procedural law here.
I don't see Laura doing much motion practice. So
I know, I'm sure David goes straightforward.
Oh yeah, without a doubt. It's littered with his DNA, shall we say?
Ah!
Sorry.
Why would you say that to me at such a late hour before bed?
Sprinkled.
Ew, you guys are nasty. You're worse than me tonight, anyways.
Don't get me started, Lauren. Don't get me started. I'm trying to behave. My first appearance and all, you know.
Oh, don't do that. All right. California law provides no authority to strike a motion to disqualify. Let's see. Rule 3.1322 does not apply to motions. Gingras seeks to strike the motion to disqualify. Under California law, motions to strike are limited to pleadings, not to other types of motions filed in litigation. Any party may serve and file a notice of a motion to strike the whole or any part of a pleading within the time allowed to respond. Notice of motion to strike, complaint, or pleading. Let's see. Extension of time to answer. The statutory framework specifically references striking the answer of the complaint or a portion thereof. Serrato's motion to disqualify was not a pleading, such as a complaint or answer, but rather a duly noticed request for an order in an ongoing case. There is no rule or statute that authorizes one motion to be summarily stricken by a counter motion simply because the opposing attorney dislikes its content.
Oh my gosh.
Yes. The disqualification...
I mean, this basically means like Gingras is like inventing his own procedure. And he's just completely off the rails. He's just off the rails. That's what this is arguing.
Yeah.
Oh my goodness.
Which is true.
Yeah, it usually is true. The disqualification motion was procedurally proper as a notice motion seeking judicial relief rather than a sham pleading subject to being struck. Where have I heard that before? Yeah, all right.
Oh boy.
The proper response to a disqualification motion is opposition, not striking. So, I mean, that's kind of more of the same. But the disqualification motion addressed legitimate legal issues. Okay. There was nothing irrelevant or improper about the content of the disqualification motion that would warrant striking it. The motion raised serious and valid concerns under well-established ethics rules. Trial courts are empowered to disqualify counsel through this inherent power to control the conduct of ministerial offers in furtherance of justice. The determination of a motion to disqualify counsel requires balancing the interests between a client's right to counsel or of their choice and the need to maintain ethical standards of professional responsibility. The disqualification motion detailed legitimate concerns, including Gingras' role as a key witness regarding material events and potential conflicts of interest. It is indisputable that Gingras is a key witness regarding the June 2024 incident, invoking the advocate witness rule, which generally bars an attorney from acting as a trial counsel if he is likely to testify on a material matter. California courts have repeatedly affirmed that they have discretion to disqualify an attorney in such situations to avoid prejudice and protect the integrity of proceedings. Okay. Gingras' indication that he wouldn't continue as counsel does not render the motion improper. If anything, it confirms the motion's point.
Yeah.
Gingras was bound to become inflamed. Sorry. Gingras was bound to become inflamed at Marraccini's characterization of the evidence and the
I
risk.
think there's a cream for that.
We don't have any preparation H here, so. All right. And the risk in not filing this motion to disqualify. There's nothing I love more than my own jokes, guys. Then the risk in not filing this motion to disqualify was Gingras entering at the 11th hour to disrupt proceedings. His sensitivities are on full display in his moving papers.
Well,
Serrato's filing.
Statement.
Yeah. Serrato's filing simply ensures that Gingras's withdrawal was made official under cloud of conflict so that he could not later re-enter or influence the trial on behalf of Owens. That's a pretty basic thing. Okay. Gingras's centerpiece request to sanction counsel under CCP section 128.5 is utterly without merit. This law allows a court to award attorney's fees or expenses against an attorney who engages in bad faith tactics that are frivolous or solely intended to harass. That's not what happened here. So, Gingras promised false statements to the court. They do not exist. So he what? So he provided them himself.
Dun, dun,
no.
Dun.
Gingras's motion hinges on the accusation that Serrato lied to the court in a disqualification motion. The supposed lies boil down to 3 statements in Mr. Serrato's filing. 1, that Gingras continues to represent Miss Owens. 2, that he has a personal conflict of interest that materially limits his ability to represent Laura. And 3, that allowing Gingras to continue as counsel will prejudice respondents' rights and undermine the integrity of the proceedings. Okay. The first alleged representation was never made. This allegation from Gingras is a blatant lie to the court. So they're both just being like, you lied to the court. No, you lied to the court. But one of them actually did. It was David. So the motion stated specifically, David Gingras has since indicated to counsel Omar Serrato, both verbally and in writing, that he does not intend to represent Laura Owens in the proceedings. Serrato was forthcoming about the conversation. If the motion nonetheless referenced allowing Gingras to continue as counsel, it would be after the disclosure of Gingras's intent and completely moot unless Gingras attempted to continue as Owens' counsel. Okay. I think we're good there. A 66-minute phone call was had where Gingras discussed continuing the October hearing for months to allow time to litigate. He spoke as a man who intended to represent Laura Owens. After the motion was drafted to disqualify Gingras, he then stated his intention not to represent Owens.
Busted.
Serrato's phrasing... What? Go ahead.
He discussed continuing the October hearing for months. I thought he said he could have this whole thing wrapped up in 15 minutes.
Dude, but I'm sure that's not the first time he said that to a lover, but, whatever.
Only after compelling lunch.
I mean, it just sounds like he's saying one thing to the court and another thing on this phone call. Which is
David
a red
be
flag
duplicitous?
to me.
No, Bruce.
Yeah, I mean, that's why it's...
I'm sure he meant that with absolutely pure intent and motive.
I guess.
Okay. All right. Anyways. Serrato's phrasing does not... Sorry, I'm still...
Lauren's having a moment. Give her a second.
All right.
Dang, Lauren.
I was trying not to have a meltdown, and then I'm like, I'm okay. I collected myself.
Why would you have a meltdown?
Because you
a
guys
search warrant being executed in your room there before 7 a.m.? Or
fuck you guys, or whatever Laura said.
Oh, hey, that's got to be worth some super chats right there.
For sure.
Come on, people. Come on.
I was not expecting Laura Owens to have like an iconic double flip.
I know.
That was...
And it was like hood angles too. It wasn't.
Yeah.
She had practice. It's like.
I thought that for sure. I thought for sure she would be composed in a way that makes her seem victim-like, but instead she acted like a fucking psycho. So
I was hoping for this for her. I thought, there's no way it's going to be, because of all the stories we've heard in the filings, with Mike and Greg and how just horrific she behaves.
Yeah.
I'm like, okay, everything we've ever seen with her is absolutely manufactured and curated. It's all for show. Mm-hmm. So seeing her when she is caught off guard, like you said earlier, Lauren, backed into a corner, it's like, oh, we're going to see the real Laura. We're going to see it. And boy, did we. Holy hell.
That was bad.
Yep.
New Grammys.
Oh boy.
Thank you for the $2. This stream needs way more oh boy from Bruce.
It's better than oh my.
Is it? I don't know.
Well, I guess it depends on if you like George Takei.
That's the George. Yeah.
I don't know. Okay.
Am
Bruce
I
is
dating
gonna hate
myself
this.
again?
Bruce is gonna hate this, but I'm asking
What?
you to read this part here from line 20 down to the bottom of the page while I go to the
Where
bathroom.
are we? Oh, okay.
We need bathroom music.
No. No.
Yeah, you're fortunate. Voice mod is not loaded tonight. I am caught very unprepared.
Oh.
The fact that you made that suggestion makes me want to hurry up, so I'll be right back.
Does your bathroom have a sink? Okay. Anyway.
Did you just ask if my bathroom has a sink? I don't walk around with like nasty bathroom germs, Bruce. So yeah, my bathroom has a sink.
I've seen a casita where it didn't. But anyway, let's see. Line 20. Serrato's phrasing "does not intend to represent" was a fair description of the situation. Yeah, what I remember was he didn't put it in quotation marks as if he was directly quoting Gingras.
Yeah.
He was summarizing or describing the situation, not directly quoting.
Yes.
But then Gingras made it seem like he had been directly quoting him when he wasn't.
Of course. Well, and if David, David's always going to misrepresent it to whatever favors him,
Yeah.
So
it seemed inaccurate.
Yeah. Well, of course. And, all of his cagey writing.
Mm-hmm. It left open the possibility that intentions might change or needed to be formalized by court order. There was nothing malicious or deceptive here. In fact, Gingras' own declaration reveals the real disagreement. He wishes Serrato had worded it "no longer represents" instead of "does not intend to represent." Quibbling over verb tenses is not grounds for sanctions. Yeah, I mean, they're just the whole thing like, well, you lied. No, you lied. I mean, to me, it's all, when I see this from a management perspective, I just see two people who are talking past each other.
Yeah.
Which often happens, in corporate work when there's emails flying around and people can't get on the same page and they just have a disagreement. It doesn't mean that everybody's a lying liar who lies. It's just,
and I can't imagine David being any other way. Because we've all heard Omar reflect on his conversations with David, and it's like, well, not only how can you get a word in edgewise with that guy, but how can you have a meaningful conversation unless you're acquiescing to everything he says and what he wants? Yeah. So I can't imagine him being any different even in his filings. So it's all adversarial in the weirdest of ways.
Yeah.
But I mean, it just comes down to, I think, to David's incompetence as an attorney.
I agree. The substance was conveyed to the court that Gingras was stepping aside, which is true. There was no false statement of material fact. The second allegation: everything Serrato stated about conflict was factually supported. Gingras is, quote, the subject of a pending state bar disciplinary proceeding arising out of his conduct towards respondent in this case, unquote. That is true, and it was supported by evidence. Gingras does not deny the disciplinary case exists or that it involves the June 2024 incident with Mr. Marraccini, which is what he should do if he's going to represent those statements as lies, lest he himself materially misrepresent material facts to the court. And I think he was the one who actually talked about the disciplinary case getting referred, right, by the bar guy in his blog, his own blog, right?
Yeah. Chat, make sure you tell Lauren to use lots of soap. I see you guys talking to Lauren in the bathroom. I see it.
Moist hands. Oh, boy. Yeah.
It's bad. I have to look way over here. I've got too many monitors to do this. I'm drowning in my own technology.
I know. I can't wait to get a real monitor set up again. Let's see. Where were we here? Okay, we were down on line 5.
Second allegation,
right?
weren't we?
Yeah. Moreover, Gingras quote, has stated he intends to use this case to elicit testimony from Marraccini that will aid in his defense, unquote. That's amazing. That's an amazing admission in that bar proceeding.
It was stupid.
Yeah. I mean, that's, if you want to get Marraccini to say certain things that will help your bar complaint situation, how do we know that those things aren't detrimental to your client, Miss
Exactly.
Owens.
It demonstrated that it was self-serving for him to even be involved.
That's where the conflict of interest comes in.
Precisely.
Okay. Let's see. Yeah, this statement is supported by Serrato's declaration and the declaration of Rachel Juarez, who is a recipient witness to the phone call referenced by Gingras. Oh my gosh, do we get a declaration by Rachel Juarez in this document?
I would lose
because
it.
That's what we need.
I think Lauren would adore that.
That'll be very exciting.
Lauren
if we
would
get to read that.
I think we need to get Rachel on the channel here for Lauren. I don't know what that would take. I don't know if Reality Steve would put in a good word.
Yeah.
Although
here's
Rachel
the problem. If she's writing a declaration, or if she's representing Marraccini, then
she's not going to say much.
She's going to be off the radar for a while.
I would love to be a mouse because I've got some theories, but I haven't seen enough said about it yet.
Mm-hmm.
But can we say the dream team of representation for Mike at the moment? I mean, really?
Yeah.
When I saw that, who did I hear it? Who said it first? I was sort of stunned for once. It's like, oh my God, Rachel's in this too? But she's kind of on the sidelines and we can't talk about it. What's going on? What else is waiting for either Laura or David or both? Or what's next?
Yeah.
There's got to be more. There's got to be more to this.
Well, I mean, trying to get a permanent lifetime DVRO against Marraccini in California at the exact same time that Laura is under felony indictment in Arizona.
She's on the ropes.
This is like kicking a hornet's nest. I mean, I don't know. It's not a good look. It's not a good idea.
Those bruises are going to turn into something else for poor Laura.
Oh, boy. Oh, no.
Woo.
Lauren, where are you? Yeah. Back here.
She must be
the next
really
page.
Wash up, Lauren. Really wash up.
What she told me once was she doesn't even go to the bathroom. She just takes a walk around the block. Or,
damn it, Bruce!
Makes a sandwich or plays
makes
with her love loves.
Who's eating a sandwich at 10:30
Writes in
p.m.?
her diary.
Grabs an ice cream.
I haven't written in my diary in at least a day.
Yeah.
In the last 45 minutes.
Uh-huh.
No, I heard what you guys were saying, and I ran back up here so I could ask. Who started the rumor that I don't use hand soap?
Oh,
no. We were saying to make sure you use hand soap because
why would you need to make sure?
We saw the chat going on. We saw the potty talk in the chat.
There was no problem with my hand soap. Rosalind sent me some. It's got a picture of me and Laura's red sweater on it.
And it's soap?
Love it.
Yes, it's a soap dispenser, and she also sent me flip-flops for Christmas.
Is that all part of the merch that was with the boxer shorts and everything?
Yeah, she did a fundraiser for
it was a whole thing. I missed
guys'
that.
legal funds. Yeah, last year, and she
totally
used that picture of me with Laura's
typical
sweater.
Rosalind Duke. Typical.
Yeah.
She should do another. I mean, now we need some criminal trial merch. Seriously.
Yeah, I guess we do. All right, what did I miss here? You guys were on something when I came.
We're at the
bottom of the page, line 9.
Okay. Let's see. Oh, you were asking about Rachel and her declaration. Yes, it's in here. Not in here, but it's in the next one.
Ooh.
Yeah. Okay. Yeah, I don't know who that is really, but she's okay.
No, I heard it. I heard it somewhere in some back alley once. A name, Rachel. What was it? What was that? Whispered tones.
Okay, well, I don't know anything about whispered tones, but
or yell
some
from
lady
the rooftops
from Reality Steve's channel. I think she was like a Bachelorette contestant. I'm not sure.
On season 12 of the pilot episode.
What?
Season 12 of the pilot episode. That is a long pilot.
Yeah. See.
All right. Anyways, where are we at here? Second allegation. Is that where we're at?
Line 9.
Oh, line 9. All the way down here. Okay.
Yeah.
I don't even know anything anymore. All right.
We were reading the document like you told us to, Lauren.
I know, man, but you're supposed to know that I can't keep up.
Oh.
Yeah. All right. Gingras has never refuted that he made such statements. Indeed, it aligns with common sense that he would want to clear his name by extracting favorable testimony. These facts lead to a straightforward conclusion. Gingras has a personal stake in the case, defending himself from discipline that could conflict with Owens' interests.
Exactly.
For example, Gingras might conduct the DVRO trial or advise Owens in a way designed to justify his past actions, rather than solely focusing on Miss Owens' current protection needs. This is a classic Rule 1.7 concurrent conflict scenario. Whether Gingras agrees that it materially limits his representation is irrelevant. If he disagreed, he could have represented Owens and opposed the motion to disqualify. It is a reasonable assessment of risk, not a knowingly false factual assertion. Whatever the characterization, when we are arguing the interpretation of facts, there is no lie. Yeah. Okay. Third allegation. This statement is plainly an expression of legal opinion or argument, not an objectively verifiable fact that can be true or false. Serrato, it's so weird calling him Serrato. Omar asserted that if Mr. Gingras were allowed to continue as counsel despite the conflict and witness issues, respondents' rights would be prejudiced and the proceedings' integrity would be undermined. Gingras bizarrely calls this a lie. This statement is plainly an expression of legal opinion or argument, not an objectively verifiable. I know how to talk. Fact that can be true or false. Oh my god, this is worse than call Feifei. Like, I can't.
Oh boy.
All right. Serrato genuinely believed. Okay, Omar genuinely believed and still believes that this is true. There is a solid foundation for this opinion. An advocate-witness situation inherently threatens the fairness of a trial, as recognized by California case law. Likewise, the lawyer with a personal agenda could skew the presentation of evidence in ways that harm the opposing party. One may disagree about the degree of prejudice, but treating this as a knowing falsehood is absurd. It's advocacy. Importantly, the court is fully capable of judging for itself whether such prejudice would exist. Omar wasn't hiding anything that would prevent the court from making an informed decision. No sanctionable misconduct can be predicated on this kind of statement. Okay. He did not knowingly make a false statement of fact or law. He presented facts supported by evidence and arguments supported by law. Gingras did something else, which is usually the case. Gingras' own filings confirmed the core facts. He appeared as counsel on August 15th, withdrew, and had a personal entanglement with the case. Far from misleading the court, Serrato equipped the court with irrelevant information, even quoting Gingras' intent to withdraw. Gingras appears to be satisfying an inability to avoid involvement in this case. Okay. If Gingras felt a nuance needed clarification, that could have been handled through a straightforward opposition or a simple notice to the court that he was no longer representing Miss Owens. Instead, he chose scorched earth accusation.
Exactly.
The court should firmly reject the notion that any false statement occurred here and consider whether or not Gingras himself has ironically misrepresented material facts to this court.
Yeah. Well, that was exactly Ian Runkle's argument this morning, that he could have just sent a simple notice to the court that he's no longer representing Miss Owens and wouldn't in the future, and they would be done.
No more than 3 sentences, I think he said.
Yeah. You just do a 3-sentence notice and you're done. Instead, he did this, what do they call it? Scorched earth accusations. Can we see what the number 3 was up above real quick?
Yep.
With this one, because this is interesting.
Number 3 was...
There was he had a bullet list of 1, 2, 3. No,
or
no,
were you
no.
looking up further?
There was the little tiny list.
This one?
Right here. That allowing Gingras to continue as counsel would prejudice respondents' rights and undermine the integrity of the proceedings. Okay. Respondents' rights. All right. Yeah, I mean, the whole thing is that this number 3 is basically a matter of argument. It's not it's not like 1 + 1 = 2. It's not like something you can go confirm. Is there $5 in my wallet or not? Yes or no? There's no yes or no answer to this number 3. So you can't claim that Omar's a liar about it.
I mean, you can, but you look stupid.
I mean, yeah, it just doesn't make any sense. It's a non sequitur. It doesn't make a lot of sense. Okay. No, I think I'm getting there.
Okay.
Have a little more, Bruce. You'll be fine.
Yeah, I'm working on it.
There you go.
Gingras' own filings confirm the core facts. He appeared as counsel. withdrew, and had a personal entanglement with the case. Far from misleading the court, Serrato equipped the court with relevant information. If Gingras felt a nuance needed clarification, we went through that already. Scorched earth accusation, blah, blah, blah. B, the disqualification motion was neither frivolous nor filed to harass. I don't think Omar has been harassing at any point in time. I think David called him repeatedly and wanted to be friends, and it didn't work out. So now he's mad. But okay.
Yeah.
The bromance ended rather quickly.
Oh, it never got started.
Well, maybe in David's mind it might have, been brewing, but
Omar, were you breadcrumbing David? Were you breadcrumbing?
If you're not a lawyer on the case, how is a motion to the docket harassment? You're not on the case.
Because he didn't want to date him.
It's like it doesn't even go to you.
It's clear harassment.
Omar was happily married and David was spurned by his rejection, just like Laura.
It's like if my neighbors were sending mail to each other through the post office. Like, it doesn't have anything to do with me. I'm not getting any mail, so it's not.
I'll send you
harassing
mail.
me. Well,
How are you
but
spelling that, Laura?
I'm
Never mind.
absolutely going to send you mail.
mail
It's
strippers.
Hey, send those
No.
my way. Okay, never
I
mind.
will send you mail letters in the mail, and I will be the stripper. Thank you.
Whoa.
Anyways,
There is that red
Hashtag
sweater.
Subscribed.
the red sweater's not a stripper outfit. How
Hey,
dare
it's
you?
Layers.
I wear that to
layers.
church.
Anything is a stripper outfit if you strip hard enough.
I guess. All right. The disqualification motion was neither frivolous nor filed to harass. By any objective measure, Serrato's motion to disqualify was supported by ample factual and legal basis. It is therefore not frivolous, nor was it filed for the sole purpose of harassing Gingras. Serrato articulated concrete conflicts of interest and cited on-point case law in his motion. This easily clears the low bar of any reasonable basis needed to avoid a frivolousness finding. It is worth highlighting the timeline. Mr. Serrato filed the motion promptly after the August 15th hearing in preparation for a trial that was fast approaching. The timing served to resolve counsel issues before trial, not out of delay or malice. Owens was expected not to oppose the motion, which undercuts any claim that it was meant to harass. The motion targeted Gingras' participation. Far from being vexatious, the motion to disqualify aimed to ensure a fair and orderly proceeding. It sought to prevent prejudice to respondent and protect the court's process in line with an attorney's duty. More importantly, it foresaw the scenario where Gingras, after reading Marraccini's characterization of the facts that necessarily opposed Gingras' sworn declaration, would be triggered enough to attempt to re-enter proceedings as counsel for Owens. All right. C. Gingras' intervention confirms the risk we flagged. It is a backdoor merits brief and a vehicle to re-enter as de facto counsel. The disqualification motion anticipated exactly what has now occurred. Nice one, Dave. Not Dave, David. Sorry, because there's a difference between Dave and David, as Dave Neal said earlier today on Megan's stream.
Very articulately, I'll say, too.
Yeah.
And I agree with it.
This guy's not a Dave, he's a David. All right.
A
So nice one,
backdoor merits brief? What is it,
Huh?
we got Tony Robinson here now? A backdoor merits
no.
brief.
I wasn't going to say it. I was thinking it.
Yeah.
I
Well,
don't
I'm
want
here
to
to,
talk about Tony Robbins and what happens after that.
I'm here to say the quiet part out loud.
Okay, well, we just switched roles entirely then. I don't even know what to say to
Bruce
that.
is going to demand a raise now.
Yeah.
All right. Well, I can give you like $3 an hour in ad rev.
Hey, that's pretty good.
Yeah.
Amazing.
After reading Marraccini's statements of facts that necessarily contradict Gingras' sworn narrative. Gingras' sworn narrative is never a good benchmark, but okay. Gingras was triggered to reinsert himself into this case. Unable and ethically barred to cure the problem as petitioner's trial advocate, he instead styled himself as an intervener and sorry, it's so stupid. And lodged a motion that purports to police material misrepresentations, but in substance rehashes and advocates the merits of the DVRO renewal and attempts to rehabilitate his own declaration. That is precisely the scenario Rule 3.7 is designed to prevent. A lawyer witness trying to argue the case from counsel table and the witness stand at the same time here by converting a sanctions/intervention filing into a surrogate trial brief.
Mm.
Gingras
That
says
could
his
be
motion.
entertaining.
I mean, yes, but we don't want that.
That would
Like, yeah, it
that
would be
make
hilarious,
media
but-
coverage worth it. Now I'm going to
Hilarious,
here.
but I don't want to see. I don't want to see it actually happen. I mean, I do, but I don't. You
It'd
know,
make a
like,
great cartoon.
Save that shit for reality TV. This is
maybe
what I'm
he's
talking about.
confused. Maybe this is an audition for him.
I said this months ago, and Omar was like, okay, so let me say this. I said this months ago. I want a court where, people without lawyers go and they like hash their shit out, and then judge or judges will make the determination. He was like, that's small claims court. I'm like, no, because I don't want it based on law. I want it based on feelings. I want it to be chaotic. I want it to be chaotic.
Let's just throw it. We need a mud pit. We need to wrestle it
like
out
a
in
messy.
mud pit.
It's like court of mess. Like it
Isn't
has
that
to be.
what is it, Judge Judy or whatever? Isn't that
Judge Judy? Judge Judy does the law, right? Judge Judy
like
actually
Judge
cares about the law.
Yeah, she does.
Do they?
Yeah.
The People's Court? I always thought it was more about feelings. I don't know.
No, I wish it was
Judge
though.
Judy's not
I'd
People's
watch the
Court.
shit out of that. No, I only watch Rachel's show. I don't watch that.
Oh.
Shit. Yeah. So I mean, it's pretty good, but again, they care about the actual law. So I'm like, no, I want to see some shit where people are just like, I'm in my feelings, and this is what's gonna happen.
Oh no.
Yeah, I don't want like professional, law-abiding people on the show. I want it to be like a messy, like feelings court only. Like that's all I want.
Rachel Juarez, Lauren has a proposal for something to produce for you.
Wait.
No.
You want people to go argue and judge each other based on feelings? Isn't that like most of reality TV, like
That's
Real
Dr.
Housewives and?
No, dude.
Yeah,
Dr. Phil is a psychologist. He wants to like fix problems. I want to make problems. Okay.
That's reality TV.
I want to create problems and I want to make them worse.
Yeah.
And
That's
I want
like
to
the
make them worse
Secret
for my
Lives with
entertainment.
Mormon wives and whatever.
I haven't
Real
watched any of that.
Housewives. Aren't those shows? Isn't that what those shows are about? I don't know.
I think you guys just don't understand messy enough to get my show idea.
I wouldn't say that, but we'll have to talk more off camera about that.
We have to storyboard it. Yeah, it could be a good show.
We got this.
It could be a good show.
Hey, doesn't Steve have lots of money? It could be produced by Reality Steve.
No, we could do because I'm kind of like off the rails all the time. So we could do me, Bruce, who's very much on the rails, and then you
Bruce
could be on.
Is
and
the
then
rails.
we have to have an even number of judges just to make it chaotic, right? So we could all be on it, and then we'd have to have one other who's like very. I know, because you're kind of measured too. So one other who's kind of like me, who's just like, I want chaos.
Chaos.
Who wants chaos? You can join.
What is that? Chaotic. Help me. Chaotic evil.
Oh, no, dude.
Is that the D&D alignment? Yeah.
That is one of them. Yeah. There's like law versus chaos, and then there's good versus evil.
No, this is all just evil.
But can you imagine if Reality Steve produced a reality TV show? That would be amazing.
I'd watch that.
Yeah.
Lauren is going to be the next Bachelorette. Oh, I would rather eat concrete before it dries out. Holy shit.
Before it dries out. Yeah. Well, okay.
Yeah, because I wanted to dry out in my stomach so I die. Anyways,
wow.
Yeah, I don't want to be the Bachelorette, man. I really don't want to be the Bachelorette.
I wouldn't either.
What if it was Reality Steve's show?
Yeah, I would do that.
But
not as it is now.
Reserved.
Yeah.
I would do some Reality Steve shit. I wouldn't do it as it is now.
ABC
None of that ABC bullshit.
No.
It's not happening.
It's trouble.
Karen Carson, hey man, it's Layman Court with your host Lauren in. Thank you for being a member for 14 months. Let me move that. I'll move these really quick and then we'll go to the next one. Christina E, thank you for being a member for 4 months. Oh boy, that's a Bruce quote.
Oh boy.
Paid endorsements.
Mm-hmm. Bianca, thank you for the 10 Australian. Oh boy, hashtag oh boy. We got another Bruce quote. All right.
If you can get that trending over tramp stamp lawyer, I will be duly impressed.
No.
All right. Remind me later and I'll work on it with all my might. Benny the dog, thank you for the $10. Thanks for covering this, Lauren. Much appreciated to Bruce and Tabernacle too for taking your personal time to bring us the details, and Ninja. Thank you very much. Appreciate that.
I wish Schnitzel was here. That'd be fun.
Yeah, I think she's been busy lately, but she also I think she helps a lot with getting the body cam footage and the filings and stuff. And I know she's doing a compilation.
Schnitzel and everybody. It's just extraordinary.
I mean, that compilation video is going to be like over 2 hours, over 3 hours maybe. So
it's
going to take a while.
I was really struck by her video where she read through all the Laura emails to Clayton all at once.
Oh my Lord.
Because when you hear them all at once, it's like it hits you how unhinged it all is. Versus, seeing them in a filing or seeing a quote here or there over time, right? Which kind of dilutes it. It was a really interesting retrospective on those emails.
I think for me also watching Laura scream, "Look at what you've done!" to police officers who are trying to look through her house because she committed crimes all over the place was my wake-up call.
Maybe.
Yeah. New Grammy, thank you for the 5. Did she show a mealy or moist? Oh, I hate you guys.
I need to look at that closer. I was watching on my phone. It's like, I don't have a big enough phone to really
I felt
tell.
like it was more of a dry bird, you know?
I think so.
Yeah.
I think so. I think it needed some moisturizer on those hands.
Thank you for the Jeopardy music during my bathroom break, New Grammy. I appreciate that. Rach G, thank you for the 5. Judge Judy created a hot bench. It's why I knew Rachel. Oh, yeah, she did.
Oh, that's right.
I like Rachel better than Judge Judy, though. So, you know, whatever. Just saying.
Hot takes.
Hot takes.
It's not that hot of a take. It's a pretty obvious and predictable take.
Okay.
But
everyone can have their proclivities.
Guys, where did I leave off here? Because we got off on a tangent there, and that was my fault.
We scrolled up a little bit, so I think we got to go back down.
Back down.
Is that right? Because we went to look at Bruce's number 3, and we
stopped.
I think somewhere in the middle.
Okay. We're going to go with this. Gingras says his emotion is about candor to the tribunal. The paperwork says otherwise. Most of his pages are spent recasting the June 10th incident. Okay. Mm-hmm. Abuse of procedure in court process, intervention, and sanctions are not a license to file a shadow merits brief. Circumvention of Rule 3.7, advocate witness. The advocate witness prohibition does not evaporate because the lawyer changes captions from counsel to petitioner to intervener. Conflicts in credibility become the sideshow, allowing a non-party lawyer to use motion practice to defend his own credibility and attack respondent's version drags the court into a collateral trial about the lawyer, not the parties, which is exactly what David Gingras wants. Attention. All right. Gingras' filings do not remedy any supposed misrepresentation. They confirm the need for disqualification. Gingras' characterization of the disqualification motion as having no purpose other than to harass is unsustainable. Okay. D. Gingras' accusations regarding YouTube videos and rhetoric are irrelevant and overblown.
Wow.
No.
Gingras levels an extraordinary allegation that Serrato threatened Owens and her now former counsel with physical violence in YouTube videos. That is not mere rhetorical flourish. It is an accusation that an officer of the court made criminal threats. If true, it would be disqualifying, but it is not true.
Did
the
he
record
challenge
is
him
empty.
to a swimming match?
God, no, that would have been a leg up for David.
That is violence.
Sorry, Omar. Yeah. I'm just trying to be honest. I mean, I don't know. I've never seen David swim, but I've seen Omar swim. And so I'm going to say that would not be a fair fight. The record is empty of any threat. The videos Gingras cites are still publicly accessible and complete transcripts are readily available. Like, there's nothing to hide because he didn't do anything wrong.
Yeah.
They contain no threats of violence towards anyone, neither Owens nor Gingras, nor does any video in Serrato's catalog. What Gingras points to boils down to A, a single colloquial phrase, want the smoke, not again, and B, a satirical, obviously doctored thumbnail image used for comedic effect. And the thing is, with these doctored images, which is really just like fair use editing or whatever.
Fair use.
It's because David and Laura both will try to copyright strike your video and get your channel taken down if you use an actual legitimate photo of them.
Still marked safe.
Yeah, no, I know, right? But
I'm inviting that now, aren't I?
I and Dave and Tug, and I believe one other, I can't remember who it was though, at one point last year, like a year ago yesterday, because I saw it come up on my memories or whatever, and it was like, oh God, I remember when that happened. Tried to strike us and get all of our videos removed for using genuine, like, good photos of them, respectable photos of them. And Laura tried to strike them. So like you have to, better. At this point, you have to make fun of the photo. You have to edit it in a way that's like funny and creative. Otherwise, they try to get your shit removed and they keep harassing you with these false copyright complaints. And what can you do? So like you use a respectable photo of them, they complain. And you use a photo of them that's bad and funny and edited, and they complain. So what are you supposed to do at that point? You do the thing that is more like obviously legal and within your rights, which is to do the funny edited photo.
Of course, it has nothing to do with what you use. It's to chill speech. That's all it's for. They want to shut everybody up.
And I think Omar's thumbnails weren't a response to,
No.
they're going to copyright strike me if I use a photo.
No, they never
It was
did that to
more-
him. No.
In the early
No, he's still
days,
mark safe too.
Because he's a lawyer. Of course not.
the thing that everybody thought was so funny was Gingras saying he was the Conor McGregor of litigation. And I guess now he's the Conor McGregor of intervention. But
if Conor McGregor never had a win, then yeah, I don't know, dude.
But back then,
Conor
you
McGregor
know,
should sue.
Omar had Dominic in the office doing a lot of production work, and he was the one who actually made some of these Photoshop thumbnails for Omar's videos. It wasn't even Omar himself.
Yeah, he had
It
staff,
was-
for heaven's sake.
Yeah, it was Dominic who was making some of these early boxing photos and stuff, and he would do it to sort of poke fun at Omar more than poking fun at anybody else, because he kind of made Omar look silly too in those thumbnails.
They were pretty good.
So
I kind of miss those days where he had all those people on the
Yeah.
show.
Well, everyone's being sued or threatened with ideas, so you know. The record is empty of any threat. I think we just read this part, right? So I want the smoke, the thumbnails. Okay, California law requires a true threat, not rhetoric or hyperbole. That's pretty self-explanatory, and David
Yep.
obviously didn't have that. There's a footnote here that says, over the past 18 months, Gingras' actions in this matter have demonstrated a pattern of erratic and unpredictable behavior. This is exemplified by a conference call involving Serrato, Rachel Juarez, and Gingras, during which Gingras exhibited difficulty maintaining focus, communicated at an unusually rapid rate, discussed personal grievances, and indicated that he required Marraccini's testimony to support his defense in an ongoing Arizona State Bar proceeding. And you know, David's just like sitting in his house crying at this right now.
So it was not only a venting, it was verbal diarrhea.
Right. Given the imminence.
I want to hear
of
this
the-
conversation.
well, he's
badly.
telling on himself. I mean,
Yes,
it's really
he is.
Given the imminence of the trial and the uncertain prospects, okay, circumstances provided a concrete basis for the motion to DQ. All right. Context Gingras omits. The videos predate Serrato's representation and were part of a public legal debate with David. So, and I know because I still have a copy of the video between, you know, David and Omar where they went back and forth. So they were never on the same video, right? But like Omar said, this is a response to David's whatever, or a critique of David's whatever. And then Omar said, responding to Omar.
Yeah.
So, you know, that's dumb. Let's see. Irrelevance and prejudice, even if the court credited Gingras' spin. Even if the court were to accept Gingras' strained reading of slang and satire. None of the third-party YouTube ephemera, is that how you say that, ephemera? Okay. Is relevant to the questions actually before the court, whether Serrato's filings were frivolous or in bad faith, or whether Gingras can ethically continue in a dual role. All right. And then here they say, it is, in this footnote, it is observed that much of Gingras' online content, including social media posts and YouTube videos, is no longer publicly accessible, while the Arizona State Bar is conducting an ongoing investigation concerning his public conduct on these platforms. The reasons for the removal of this content have not been expressly disclosed in the record before the court.
It's true.
It's not unavailable. There are ways, and
Yeah, but he doesn't know that.
it. Yeah.
Well, it's not made available by Gingras himself.
No, definitely not. Right.
Kind of.
So even if there are archived copies,
They're like
still
old
up.
archived.
They
links
are
and
still up.
posts.
They're just unlisted.
he's just
And
unlisted. Yeah,
I can tell you that from direct experience because someone sent me their playlist of it.
Oh.
We're sharing secrets. You didn't hear that.
It doesn't matter. I have them all downloaded. So,
Well, it's better to have physical copies because the day will come where they will disappear.
tomorrow, yeah.
If they haven't already.
Let's see. Gingras' theory that Mr. Serrato filed the motion to disqualify to create new YouTube content is unsupported and unreasonable. Serrato filed one motion on a serious issue and has not created any content related to Owens or Gingras since entering this case in August 2025. He cannot control the content practices of other creators who continue to cover this case because of the public interest in Owens' conduct. All right.
And it's only increasing.
Gingras' online war with the public who follows this case threatened lawsuits, retaliatory takedowns, and direct attacks on respondents' counsel.
Wait, that's us.
Never heard of that.
Hey, speak for yourselves.
A striking portion of Gingras's filing is devoted to YouTube videos and commentary created by people other. Oh no, Omar. Okay, sorry. Other than respondents' counsel, complete with screenshots and links, including a court of random opinion video and other channels' content. No, not yay. I don't want to be involved in this. Like, what the
I know it just distracts you from.
Everybody, leave
Blake
me out of
Lively.
your shit, bro. I got enough with Blake going on. All right.
Leave me
Video
out
and
of
other
it.
channels' content that Mr. Serrato did not produce and cannot control, and that is true, guys. Mr. Serrato has given me much good friendly advice, not lawyer advice, over the year and a half that I've known him, and I did not take it a lot of the time, so it's not his fault. Gingras's declaration likewise parades thumbnails and insults he attributes to the Tilted Lawyer channel and friends, again conflating independent creator speech with litigation conduct in this case.
Yep.
This is telling his true dispute is with those third-party commentators, not with any action or tactic by Serrato, cognizable under the sanction statutes. That matters for at least 5 independent reasons. Okay. Well, just kind of thoughts on this right here. Again, Omar does not, like he said right here, control the things that I say and do. I think that I would probably be better off if he did, but he doesn't. And I don't take his advice much of the time that I ask for it. None of that advice has really had much to do with David Gingras, with the exception of that copyright issue over a year ago now, or actually, no, it's been a little less than a year.
Yeah. 10 months?
Yeah, it's been 11. I
Ish.
think. So I was in Australia last year for my birthday, and that's when that happened.
Yeah.
So that was a month less than a month shy of a year. So yeah. But other than that, he has not given me any real advice regarding David Gingras or what to say or what not to say. He's just kind of been supportive, and I've expressed my frustrations at times, to which he's been like, "Oh, Lauren, why do you care? He's not that important." And I said, because I feel like a psycho when I read his his bullshit. But that's about it. He doesn't ever tell me what to do or what to think or what to feel. He just kind of lets me have my moments, and God knows I have them. Every time this man gets on his soapbox and writes a little internet paragraph or does his videos. So it's not his fault. I can speak to that personally. I'm sure he would prefer if I just moved on with my life and didn't. But at the same time, I feel very upset about some of the issues that are presented in these cases. So I don't. I continue to sit here and to talk about it. So, and it is what it is. It's not his fault. That is at no one's behest. I do what I want to do. The reason I like YouTube versus other jobs that I've had is that no one can tell me what to do or say. Even if somebody doesn't like my opinion, even if they don't like my topics, that's not their fucking business, and they actually can't stop me. So that's the first time I've ever been able to say that. Is like I can do what I want. So taking that kind of autonomy out of it and accusing this man of having something to do with the things that they do and the way that I conduct myself is kind of stupid, in my opinion, because the whole point of me doing this is that no one else can control my actions. So fuck you.
You're
David.
out of control, Lauren.
Yeah, that's not the point.
Yeah.
But yes.
I think my perspective on the guy, like when he says his dispute is with these other people, like the reason I don't care about Gingras or I can't take him seriously is because he doesn't have a true dispute. If he had a true dispute, he would say, oh, in this Dave Neal video or in this Lauren video or this Bruce video with this URL at this timestamp, they say XYZ, and here's why I think they're wrong. Let me convince you. He never does that. He just writes a crazy blog saying, oh, well, Dave Neal is pond scum of the earth or whatever. Like
Pond
just
scum. I forgot about that.
stupid rhetoric. And you're like, well, you're not giving me anything I can actually have a dispute or a debate or a conflict and actually like something where you could convince me with good evidence, or you could make an argument and I could say, well, here's my counter to your argument.
It's
just useless. Yeah. I mean, he just has useless rhetoric. And so when Omar here says like his true dispute is with these other people, I'm like, well, he doesn't have a true dispute with me or Lauren or Dave Neal because he fails to bring a good enough dispute to the table.
Yeah.
It's just failure.
We in a fight.
There's nothing on the table for me to do.
It's all about the feelings.
No, we're in a fight, like an Urban Dictionary fight, not like
Urban Dictionary fight.
not like a legal fight. But yeah. Oh God.
Anyway.
I don't know. Somebody says, hang on. I remember your birthday, Lauren, November 17th. That is correct. That is my birthday.
Wow.
It's coming up soon.
I try
don't
to
want
forget
it.
mine.
Exciting.
No, yeah, exactly. I would like to keep mine on the back burner. I am 32. I don't need to get any older than that.
Oh, just wait, Lauren. It gets worse.
Oh God, I believe you. Okay.
The things they don't tell you when you're younger that you just find out.
Oh, they
later.
told me so many times and I didn't listen.
Really? Oh.
Yeah. Like, eat your vegetables. No, I'll be fine. You know?
We have a lot of work
Those
to
kinds of
do.
things. Yeah, Bruce, I know. We're going to start with the eyelashes, right?
Wait, what did I have to do? Cut them off or curl them or something?
Shave them off?
No, we're supposed to curl them. Yeah, we're supposed to do better.
Oh.
Right.
Like with an eyelash curler?
And you know what that is,
Little
and
mascara?
I don't. And that's the thing, isn't it?
Oh.
No, I know what it is, but I don't. We did a version of Queer Eye, but what was it called? Straight Eye? No, it wasn't Straight Eye. What's it called? It was Queer Eye. It was Queer Eye, but it was something else. And then I had a bunch of straight people, including Bruce, on to like help me with my style. Yeah, I was like, hey, guys, I need help. It's like Cross Eye. That was it. It was Cross Eye. We did an episode of Cross Eye where Bruce and Brad.
It was me and Brad.
Snitzel
I don't even remember what we told you to do. Like, I don't think you did.
Neither do I, bro. That's why I'm still here.
Oh, you know what it was? We were trying to curate a good dating app profile for you or something.
Yeah. That didn't work out.
Oh.
We certainly tried though. All right.
We should have just painted your toenails or something.
They're still available.
That'd be simple.
Yeah.
Take video, only feet.
Oh, yeah. Big money.
Right. We know about all this with the YouTube stuff. Let's see. This matters for at least 5 independent reasons. Sanctions must target litigation conduct, which this doesn't. Irrelevance and prejudice, hearsay, lack of foundation and authentication. Okay. Screenshots and clips of what others said online are hearsay. Well, yeah. No duty and no power to police independent speakers. I'm sure David loved reading that. Safe harbor theory collapse when the harm is third-party speech. Good Lord. This is like kind of, he's almost treating it as like the Greg hacked everyone thing with Laura, right? But like he's saying that everybody individually is like part of a collective single body.
It's all ridiculous. A big conspiracy.
Yeah.
Yeah.
Okay. Let's see. Further, he attempted to create a media storm by previewing his motion for sanctions, teasing its filing, commenting on it publicly, and blogging about it for days after the filing, perhaps as a gauge to see how his arguments with the public would be perceived. He wanted the attention, he invited the attention, and was anxious to see the public react to his filing. And to that, I would also point out, there was somebody on Blue Sky, which David is now using instead of Twitter. Thank God he's away from us on Twitter. But, you know, somebody was like politely responding to David on Blue Sky, engaging with him in a meaningful and not combative way and saying like, oh, your declaration came out. Will you give us a copy of your filing? And he said, you know, okay, well, if the declaration's out, you guys are going to see the motion eventually. So yeah, I might put it here. And then instead of just saying, you know what, I changed my mind again, right?
again.
He said he blocked the person, and he's like, and he complains about people abusing him in comments. I'm like, but actually, like this person was very nice, polite, and proper with you, and you blocked them because you were like, oh shit, I'm going back on my word. I guess I better get that person out of the way. Like Jesus Christ, that was a mess. So yeah. Oh no, I saw that yesterday though. I was like, I can't believe he blocked that guy. Like that guy was so nice, and he's like, JFC is terrible. JFC is blah blah blah, as if JFC is an actual cult. But then when people actually try to engage with him in a meaningful way, he's like, nah, block. Fuck.
So when are cult dues due again? I've forgotten when I need to send them in.
End of the month, bro.
End of the month. Okay, thanks,
Yeah.
Lauren. I need the reminder. It's not in my bank account right now.
Yeah, it's all good. All right. At bottom, this court is not the forum to settle Gingras' disputes with YouTubers. His motion lays that bare. Rather than confine himself to alleged misstatements in a court filing, which he never identifies with specificity, he spends page after page litigating the internet, a campaign that is neither relevant nor cognizable under the sanctions rules. All right, cool.
Or any rule.
Yeah, so they're saying the court should disregard the YouTube-based materials and arguments, which obviously makes sense. To the extent these third-party exhibits were offered as proxy to re-argue the merits of the DVRO, That only confirms why he cannot ethically continue in a dual role. He is attempting to prosecute a broad public relations grievance through this case.
Yeah.
Oh boy. As further evidence of his deep obsession with third-party content creators, the court should be aware that he has a long history of threatening and publicly feuding with content creators who don't agree with him. And then he's talking about Dave Neal, and I believe he mentions Megan Fox. Yep, Megan Fox down
Megan.
here. We know what happened there, so I'm not going to read too much into that. We'll see it in the exhibits. And then he talks about Ducky right here, the DMCA takedown on his own law firm blog, where he advertises himself, by the way, as an internet lawyer, a free speech advocate, and also like a copyright specialist. He's bragging about like taking down people's videos. All right, man.
Justice for Dingus.
Yeah.
My God.
The same blog series is used to attack the respondent's counsel personally. Gingras accuses Omar Serrato of having straight up lied to the court, announcing he moved to intervene solely to seek sanctions and a state bar referral against Serrato, an unequivocally defamatory statement that was published for anyone who follows this case to see. Alrighty then. These episodes are not isolated. They form part of a pattern in which Mr. Gingras threatens legal action. Hi. I know that.
Hi.
Bar complaints, copyright takedowns, demand letters, notices against content creators who critique or report on the Owens litigation. The timing, language, and frequency of these threats suggest they are being used to suppress public criticism and defend Gingras' personal reputation. This pattern of behavior has predictably spilled into the pleadings in Owens' DVRO renewal request. The motion should be Exhibit A, demonstrating Gingras' involvement. Okay, this motion should be Exhibit A. I get it. I think I get it. Demonstrating Gingras' involvement in the case is not only as counsel for petitioner, but also as an actor seeking to control public discourse, a role incompatible with fair, impartial representation under Rules 1.7 and 3.7.
Bravo.
Gingras did not adhere to the safe harbor procedure, and no valid exception excuses this failure, which is hilarious again because he did that. He harped on that safe harbor thing for Laura Owens in the Clayton Ecker case.
Rule 26.
Right. But then he failed to give Omar like a safe harbor notice. He didn't serve Omar with a safe harbor thing. So what? Safe harbor provision establishes a two-step process with a safe harbor waiting period. The moving party is to serve the sanctions motions on the offending party, but cannot file it with or present it to the court unless within 21 days after service of the motion or any other period as the court may prescribe, the challenged paper, claim, defense, contention, allegation, or denial is not withdrawn or appropriately corrected.
Whoa.
This procedural requirement is mandatory, and the full 21 days must be provided absent a court order. I can't believe that's the thing he fucked up. Like, what are you doing, bro? I know it's just one of many, but still. My God. All right.
Well, he's just doing a minor intervention.
Okay.
You don't need a safe harbor for that. Come on.
Just a light breeze.
Oh my God.
Yeah.
Whoa. My God. Gingras admittedly failed to comply with the safe harbor provision. We don't need to read too much more about that. Gingras' exception arguments do not apply. Okay. Recognizing his procedural failure, Gingras attempts to invoke a narrow exception to the safe harbor requirement, arguing that the harm was irreparable and could not be mitigated by withdrawal. However, this exception applies only in extremely limited circumstances where the very act of filing or the manner of filing causes a harm that cannot be undone. I think we're good there. The alleged harm does not justify bypassing the safe harbor provision. I'm not going to read too much into that. The extreme request for disciplinary referral should be rejected. Right? Gingras asked this court not only to punish Mr. Serrato with sanctions, but to make formal findings of ethical violations and refer Mr. Serrato to the state bar for investigation. This is an extraordinary request that is entirely unwarranted on the facts. It appears designed more to generate a flashy talking point for his blog than to address any genuine threat to the profession. The court should decline this invitation to overstep. Good Lord. And I feel like we've heard, again, I heard like a lot of these points here, so I'm going to skim over. But, okay. Conclusion, Gingras' motions are an unnecessary and inflammatory tangent to the real issues in this case. Gingras chose to inject himself into this proceeding and, when met with rightful resistance through a well-grounded disqualification motion, he retaliated with personal attacks and meritless requests. The court should not allow this approach. Serrato's conduct did not violate any laws or rules to warrant sanctions or disciplinary actions. By contrast, Gingras' filings exemplify the scorched earth tactics that waste judicial resources and turn a domestic violence case into a personal grudge match. Respondent and his counsel urged the court to bring the focus back to the parties' dispute and put a stop to the peripheral attorney feud. Denying Mr. Gingras' motion will send that message clearly. We ask that the court do so and allow the Owens versus Marraccini matter to proceed on course, free from further distractions. So I guess they're going to decide all this tomorrow. We have one more thing to go through.
Really?
Yeah.
I think, the strategy that was more at the start of the document about not wasting the court's time or making the court process more efficient is a good technique.
Yeah.
It is.
Because
And it's
Gingras
very
keeps
salient.
he keeps pounding the table saying, like, I think the law is important and everybody should follow the law and you shouldn't be allowed to break the law. And it's like, look, you're not the police. You're not a prosecutor. Okay. You're a lawyer. You should be trying to enable and ease litigation. And that's exactly what Omar is doing here. So I like that approach.
Yeah.
They like economy in the judiciary.
I hope so.
All right. So we got this one more thing to go through.
An October filing. It's fresh.
This is
Oh my
from
gosh.
today, I guess. Yeah, today. Or they stamped it today. I don't know if it was actually signed today. Let's find out.
Yeah.
Because there's Omar's and then there's Rachel's.
Yeah.
So
well,
look, this looked
good
like
enough.
yesterday. Looks like
So
yesterday.
tired.
Yeah, we're gonna try to skim over some of this. I know Rachel's is not very long, but Omar's is, of course. But so let's skip down to
Damn it, Omar.
motions are ready to be heard without additional briefing.
Poor Omar.
Underlying case is Laura Owens' application to renew a DVRO first issued. Let's see. So some of the stuff that we just talked about in that thing that we just read, I'm not going to go through all that, so we can skim through that. Let's see. We know about the hearings. Okay. Respondent requests rule in these matters on the pleadings. Okay. All right, cool. Oh, so this is Rachel's.
Ooh.
Yeah.
We need a
Echoes, you want to
fanfare.
Echoes, you want to take the first paragraph there so I can
Sure.
drink some water. Okay.
Right in your diary.
Dear Rachel.
Yeah. There it is.
Oh my God.
Hey, I called it. What can I say?
And it's even the proper color. I am so
Yeah.
impressed. All right. Oh, okay. I, Rachel Juarez, declare my undying love to Laura Neidigh. Okay, no, that's not what it says.
Yo, what the fuck is wrong with you?
Dang.
I don't know her like that, man. Like we're friends. I don't know her like that. Shit. What the fuck is wrong
We'll
with
work
you?
on that. We'll work on that.
No, I don't want to work on that. I like my friend. I don't want to work on that. Nah, stop it.
Work to do.
Oh, it's terrible. All right.
Read the paper, you fucking weirdo.
This sounds like phone calls to my friend, and it's a good thing he's not watching right now.
Right.
I wish I wasn't watching. Read the paragraph.
I am an attorney licensed to practice law in California. I am not counsel of record in this matter. In August 2025, I consulted with respondent's counsel, Omar R. Serrato, on attorney ethics and case management issues related to his representation of Mike Marraccini in connection with petitioner Laura Owens' DVRO renewal. I presently intend to associate into the case on behalf of Mr. Marraccini, so that I can assist Mr. Serrato as co-counsel for the upcoming trial.
Oh.
I make this declaration based on my own
Okay,
personal knowledge.
you're going to make fun of me and not Bruce after he made that noise just now. You
What
guys are
Bruce
biased
does
as hell.
just off camera
What
is
wrong
Bruce's
with you?
business.
What?
Nothing. Keep going, dude. Why don't you keep going?
Lauren's getting punchy. It's getting late.
Lauren is tired as balls. Just keep
See,
reading.
there we go. I participated in a three-way telephone call with attorney David S. Gingras and Omar R. Serrato.
Three-way. Oh, guys, it's that part of the night.
yeah.
Oh, boy.
No, hey,
I've
no,
not
no,
turned
no,
the
no,
red
no,
lights
no,
on
no,
yet.
no, no, no. I'm as perverse as they come. You be respectful to my friend here. No, gentlemen, we're gonna be better than that. You wanna talk about weird sex jokes? Do it to Omar. That's it.
Oh, I'll do it to Omar.
You better.
Damn. Omar's not here right now. That's a pity.
Now that I'll listen to.
According to the records from the cell phone carrier, we pulled records. The call lasted approximately 66 minutes. God, now I got to breathe and compose myself.
Yeah.
I will punch you in the face. Like, what are you doing?
Yes, please. Okay.
Damn.
What if
I
I
have carrier logs reflecting both the date and duration of the call.
Whoa.
My understanding of the purpose of the call was that it was to
I'm
discuss
about to
this
kick
case.
these boys off the screen. I'm not even
We're just reading the filing, Lauren. Come on.
And its possible resolution. I anticipated the call to last considerably less than 30 minutes. From the outset of our discussion, Mr. Gingras was speaking rapidly, bouncing quickly from topic to topic. Well, that's not surprising. And it was often difficult to keep Mr. Gingras focused on matters related to this case. And he often steered our discussion towards a series of legal, personal issues that Mr. Gingras himself was going through at the time and which he was eager to explain to us. Does that include his DUI case, perhaps?
Personal issues?
Which one?
I want to know. I want to know.
Among those issues, I spoke too soon, was an Arizona State Bar investigation into alleged misconduct on the part of Mr. Gingras involving Mr. Marraccini, specifically an incident on June 10, 2024, in and around an Arizona courthouse. The other personal issues we discussed are not implicated by these proceedings, and I will therefore forego any detailed discussion of them.
Oh, Rachel, come on.
What do you mean, come on? Sorry, she's a professional, smart person. Like, what do you mean, come on?
We're just jealous of her education.
We want to know.
Yeah, I know. Everyone is.
I can't help
tea.
it.
We want the hot tea.
Did she go to Yale? Is that right?
Yeah.
I almost went to Yale for grad work. Almost.
Almost. But then you want to be proper like Rachel is. That's why you didn't go.
No, I just, I was burned out and ran out of money.
I mean, honestly, valid. I couldn't imagine. If going to an Ivy League school sounds like a fucking nightmare.
I mean, I did have an opportunity to have full ride, but I just wasn't ready.
It still sounds like a fucking nightmare, dude.
Oh,
like,
yeah,
that sounds like nuts. Like, I would not want to be in that, no. So, I don't blame you.
Let's see, where did I stop? And my eyes are watering because I'm laughing so hard. Oh.
Let's see. The personal
Go ahead,
issues.
Bruce, your turn.
I do, however, remember the sum and substance of such topics and would be competent to testify about them if asked to do so. Oh, yes, please. Number 5, at some point during the phone call, we ended up discussing a concern Mr. Serrato and I had been having, the fact that Mr. Gingras was a recipient witness to disputed events underlying Ms. Owens' renewal request. Based on my review of the file in this matter, Mr. Gingras is a necessary witness with respect to the disputed events of June 10th, 2024, incident that Ms. Owens raises in her request for renewal. This is, of course, the same June 10th, 2024 incident in Arizona referenced above that Mr. Gingras said was presently the subject of the Arizona State Bar investigation, which explains his status as a recipient witness. We briefly discussed whether Mr. Gingras' rule as a recipient witness to the June 10th, 2024 incident would constitute a conflict of interest. Next page. In this matter. Number 6, as the conversation continued, Mr. Gingras became increasingly distracted and was bouncing from topic to topic. Oh, bouncing. Resulting in the discussion that was moving rapidly between this case and Mr. Gingras' personal issues, one of which, as explained above, is the Arizona State Bar investigation into Mr. Gingras that involves Mr. Marraccini. Every few minutes, Mr. Serrato or I gently attempted to bring the discussion back to a potential resolution of this matter that would not require the parties to go to a contested hearing.
Wow.
Oh,
they couldn't reel him in. Well, who can?
No.
That's hardly surprising, yeah.
As is
typical. I'm saying, like, she had to deal with 2.5 hours of that guy in Reality Steve and 66 minutes of him on the phone. Like, what the fuck?
That is a lot, yeah.
That's a lot to subject yourself to be honest. I feel like she did it voluntarily both times, so respect, you know.
Yeah.
Number 7.
She's tough as nails.
Oh, 100%.
Yeah,
As
he's
is
the best.
typical in settlement discussions, Mr. Serrato and I explained to Mr. Gingras both generically and specifically why we did not believe a live testimony hearing would benefit either party in this matter. Oh, that's interesting. So they're trying to avoid a hearing at this point during this phone call. That's news. Specifically, we discussed why we did not believe a trial would benefit Ms. Owens.
Well, that's obvious.
That's interesting. At some point during the discussion of the disadvantages to the parties of going to trial, Mr. Gingras interjected that it would, in fact, be to his personal benefit.
Ooh.
Oh, for this matter to reach a point where Mr. Marraccini would provide testimony in the case, as opposed to the matter reaching conclusion without Mr. Marraccini or Ms. Owens providing live testimony. Okay, so this is the big conflict of interest here,
Yeah.
right? These guys are saying, look, we can just settle this whole thing without going to trial. Gingras is like, well, I want to go to trial for me, but maybe that's not good for his client. Mr. Gingras, who was speaking very quickly and in a somewhat disjointed manner, went on to explain that he believed. Now, does she really mean disjointed, or maybe she means jointed? But anyway,
I think that would help him.
It
would slow him down.
Went on to explain that he believed it would be helpful to his defense of the pending Arizona State Bar matter for the renewal request to proceed at least up to the point where Mr. Marraccini would provide testimony. That seems very self-serving. Mr. Gingras said specifically that he believed Mr. Marraccini's testimony would be favorable for him in connection with the Arizona State Bar matter, and that accordingly, he had an interest in procuring such testimony in these specific proceedings. Oh my gosh. This is rough.
Rough, yes. Surprising?
No.
To the
Also
best of
serving.
my recollection, Mr. Serrato and I both interjected at that point, in fact, interrupting each other as we each attempted to point out that Mr. Gingras' personal interest in how this matter is resolved is a potential conflict of interest. I specifically recall believing and saying that this situation constituted the definition of a conflict of interest.
Absolutely, Rachel.
Yeah. Mr. Gingras immediately and forcefully disagreed that a conflict existed.
Of course he did. No.
He then stated in substance that there was no conflict of interest because his interests were the same. Next page.
Okay.
Same as his client. And
close enough.
As and aligned with Miss Owens' interests. Really? He insisted many times that his conduct had been lawful and appropriate.
Sure.
Yeah. Because when I'm just hanging out talking to people, I need to remind them that I'm being lawful.
To use soap when they go to the bathroom during breaks? Is that what
Yeah. And then I remind them that I'm being lawful and appropriate all the time. That's how
and it's all for my own needs with being disciplined by the state bar.
My understanding at the time of the call was that Mr. Gingras was counsel of record for Miss Owens in this matter. At no time during the call did Mr. Gingras say that he had already withdrawn from representing Miss Owens. That's interesting. Mr. Gingras did not also definitively say he would withdraw. That's the key problem. As explained above, Mr. Gingras was not easy to understand during portions of the phone call. His speech was disjointed and often difficult to follow, and at times he would speak in long monologues.
No.
Oh.
Absolutely not. I don't believe that for a second.
Oh, no.
That's sarcasm, folks.
He took all manner of positions and what? Oh, no. And often discussed them with himself. He's like, yo, Gingras, if you had a conflict of interest, would you be on this case? No, Gingras, I wouldn't be, but I don't, so I can be. Like,
was it like Gollum? My precious. No, let's do this. No.
Yeah.
No.
Oh, this is why I couldn't read this.
This is amazing.
This is epic.
He discussed them with himself. However, the one thing Mr. Gingras steadfastly maintained was that he had no conflict of interest in this matter and that he had not acted inappropriately or unethically. Very little was clear by the time the call ended. However, I left the call convinced that a Motion to disqualify was absolutely necessary given the enormity of the conflict of interest at play and Mr. Gingras's absolute denial that any conflict of interest existed.
Wow.
Methinks the man protests
too
much, given the potential of serious prejudice to Mr. Marraccini, were Mr. Gingras to not withdraw, but then substitute back into the case, and the relative speed of DVRO matters, I believed it was necessary for Mr. Serrato to get a motion to disqualify on file with the court. Very good. Anybody else want to read this stuff, or should I keep going?
How much longer does this go? I mean, I'm okay trashing David through the evening, but...
Yeah. Number 12. We can't hear you, Lauren.
Lauren, you're muted.
I just told you all of my secrets, bro.
Oh.
Well, I'll go back and do the lip reading later.
Yeah.
Okay.
Anyway, number
I
12.
would recommend you do that offline. I'm just saying.
Though it often delved into personal topics, the call was professional on all sides. At no point did I or Mr. Serrato threaten, coerce, or attempt to intimidate Mr. Gingras in any way. The discussion, as it related to this matter, focused on potential resolutions of this matter, case management, and avoiding collateral disputes. After the call, I learned that Mr. Serrato sought written confirmation of Mr. Gingras' status as counsel in the matter, and that Mr. Gingras later indicated in writing he did not intend to continue representing Ms. Owens. If helpful, I can authenticate the follow-up emails as Exhibit RJ2. Okay. I did not and do not believe that such writing obviated the need for a motion to disqualify. So we still need that. Indeed, due to the erratic nature of the prior conversation with Mr. Gingras, Mr. Gingras' steadfast insistence that there was no conflict of interest in this matter, my review of public documents, including the pleadings and communications between Mr. Gingras and opposing counsel in other cases, and the nature of my own past experiences with Mr. Gingras. Oh boy, that debate's coming back to haunt him. I believe it would have left Mr. Marraccini at risk for his counsel to forego obtaining a ruling that Mr. Gingras' personal interest in the case as it relates to the ongoing Arizona State Bar investigation into his conduct. She sure does like mentioning that, doesn't she? Constitutes, we need to scroll down, a conflict of interest in his representation of Ms. Owens in this matter. I declare under penalty of perjury, under the laws of the state of California, that the foregoing is true and correct. Okay, September 30th.
Rachel.
There it is. And then we have the exhibits. Good
yeah,
exhibits.
I mean, there's not much to see here that we haven't already seen. A lot of it's David's blogs, grabbing fame or just talking. Yeah, I mean, we've gone over that thoroughly. TGIF, just stop. The tea is brewing. Go touch grass.
Touch grass. Oh, no.
This is when he's like, totally don't talk about me anymore, but gives you a million reasons to talk about him. And his comment sections.
Oh, brutal.
Tiny Tuesday updates. Yeah.
Wow.
And then they have like the photos from his blogs in there too. We all have the right to remain silent, but should I? Yes, bitch.
But you can't.
Yeah, right. And then there's a photo of Dave's video. So it's like, this is like the email where Dave or David threatened Dave. And that gets confusing. I'm sorry. The Dave thing is like, okay. And then there's one of Megan Fox's tweet. These lawyers, David Gingras and Bruce Matzkin, demanded that all the coverage stop immediately or change to favor their clients who were demonstrably lying about many things. Okay.
The parallels are, well, they're not surprising.
No, definitely not. Exhibit E, another day, another lie, FML.
Jeez.
What a cunt.
He's so histrionic.
He really is. He and his client have that in common, I guess.
Oh, the drama. It's like middle school drama.
That took way. I was expecting to go for like an hour tonight. It's been twice as much. So.
Oh yeah.
Thanks guys for.
Got to go deep on this.
Yeah.
Yeah.
No, it's good reading. I mean, it's good stuff. So no complaints. I guess I'll have that hearing tomorrow, and then I'll be on with Steve at 5:30 Eastern to talk about it. And
awesome.
Yeah. So we'll see how that goes.
Busy.
Yeah. Anyways, any last comments, concerns before we head out for the night?
Wow,
are there other docket documents we haven't looked at yet, or
I don't think so. Those were the only three that I saw today. But if there is one, I'm sure I'll do it later.
Okay, so
But those
there's
are all
this
I saw.
there's
Yeah.
this emergency hearing tomorrow.
Yeah.
And then there's the actual hearing date. When is that for this DVRO renewal? That's the end of the month?
21st to 22nd, I think.
Yeah, something like that.
Okay.
This month. Yeah.
All right, so we've got that coming up. And
Are either of you going to that?
not that I
No,
know of.
Yeah,
but
I'm gonna
Megan
go.
is, right?
I think so. Yeah.
I think she's soliciting funds, as I recall.
Oh, okay.
I think some people are going to go.
Yeah.
We'll see.
Yeah, I'll be there.
I'm
I
sure
mean,
somebody
Omar's.
local will.
When am I ever
report.
going to get to see Omar do his job in a way that's interesting to me? Other than that, so just so I'm going
Those
to
are
go.
the highlights, huh?
Oh, well, you're
Yeah.
going to go. Well, that's even better.
course.
Then.
Yeah.
There we go.
Yeah, of course.
And then she'll say, oh, so boring. Omar was just doing his job and it was good, but there was no fireworks. There was no.
Yeah, I'll rag on him a lot. It'll be fine.
There's no
They'll just-
MMA cage match with Conor McGregor of intervention out in the parking lot.
No, they're going to do a separate lawsuit for that.
Oh.
You can just sit in the
Oh,
gallery and
nice.
snort once in a while and see if he notices.
Does this mealy cunt apply or not? Yes, Laura is a mealy cunt,
Damn.
That's good.
and David is
I
a
might
school
borrow that.
shooter waiting to happen. So,
Oh no.
Yikes. Hashtag
I mean,
yikes.
look at the pattern of behavior. Tell me I'm wrong. Like, holy shit! Like the
It
guy is
seems
a
like he's-
disaster waiting to happen
It seems like he's coming more and more unraveled, just like Laura is.
with his assault rifle in the background. Yeah.
I think he really needs to retire and just like do part-time flooring installation, like tile floors. I think that like
Well, he did have a
settles
Home
down.
Depot hat, right? So he's
Yeah.
at least half prepared.
When he goes and like builds a pergola or like does flooring or something for his parents or whatever, he seems to calm down. I think he just needs to like make
He
that
needs to work with his hands
a
and
side hustle. Yeah.
yeah.
Yeah. I'd love if he did it away from Florida, but
Far
that's what it
away.
is.
It's kind of like therapy. Just get off the internet and put some tiling down and just relax.
Touch some tile. Are there any
Touch some-
predictions of
Touch
his
some tile.
his disbarment or disciplinary thoughts?
Oh my gosh.
I'm on the fence that he's either going to be forced into retirement or he's just going to get disbarred. I haven't decided yet.
Oh,
Well,
no
if,
shit, man.
if the bar guy really did refer him to the disciplinary committee and he has 11 bar
taking it up.
complaints and one of them is from a judge,
The bar guy that he called demented.
then they have to do something about that. I mean, that's like a,
And then he's
that's,
got complaints in Florida and probably California too. Isn't that right? I think I remember hearing that somewhere.
Probably. It sounds right, but I'm not sure.
yeah, but I think unless they refer those things back
Yeah,
and forth,
cross
they're not going to
referral.
know.
Well, you never know. Social media has a long reach these days.
Yeah, maybe.
We'll see.
Fingers
It's
crossed.
wild.
All right, guys. It's time for me to take off for the night. It is
Absolutely.
11:30. So, thanks everybody. Appreciate it.
Thanks for having me, guys.
Yeah,
Hope
thanks
you
for
yeah.
support.
that
Yeah.
goes. Appreciate it. See you guys soon. Probably tomorrow.